Well, we should be live. At least that's my understanding. Yay, we're live. All right, good deal. So, Merry pre Christmas Eve. I have pinned my G String account where you could make a donation. And every time you go, you don't even have to make a donation. If you just go to my G String account, you will get the Christmas present of your dreams. So, what is on the screen, you're going to ask? I was in touch with an attorney. An attorney reached out for me. I did verify that he is, in fact, an attorney. And one of the issues that just didn't make any sense to me on the last stream that I did was, or maybe was it the stream before? I don't remember which, but I was told that those statement of facts by the cops were the complaint, and everybody was telling me that, but it didn't make any sense. You know, a complaint, even in Massachusetts, has to follow some very specific guidelines, and this one does it. So you can see that this one is a criminal complaint. It's been redacted, and it's not signed. It's not executed. I don't know why. He said it wouldn't be, but there you go. But he did send this to me. So this is an actual complaint that you would see in a district court of Massachusetts. This is what I was looking for. This is what would have been the actual charges that Turtleboy would have been like directly charged with, etc. So the sufficiency of the complaint is one of the things that you can challenge in a criminal matter. And those other things, while they were very obtuse, or not obtuse, they were very, they used a lot of words. I forget what word that is. It's not obtuse. Anyway, they were very wordy. They said a lot of things, but they weren't a complaint. So the next thing that I saw, this was terrible. Not necessarily terrible for Turtleboy. I mean, the long and the short of it is that that this arraignment had no real effect on Turtleboy's chances of success or failure in the long run. But what it does tell me is that the special prosecutor is close to incompetent. Very close to incompetent. What the hell was his name again? It was Mello. Kenneth Mello, right? Kenneth. Kenneth Mello, Massachusetts. And I want you to keep this in mind when we're going over this, when we're verbose. It's not verbose works, but that wasn't the word I was looking for. Thank you, Lisa, but it wasn't quite it. Everybody bust out your thesaurus. But anyway, while we're watching this particular stream, I just want to point out that divorce and family law are two of the 5 areas that this Kenneth Mello practices, which is redundant, and it says the same thing twice. What kind of criminal law does he do? Well, he's a defense attorney because he's in private practice. But he acts like a family law attorney. So keep that in mind. But we're going to go through this. We're going to watch it because I think there's a lot of little nuggets you could pick up in this. And much like a toddler with a full diaper, I like picking up nuggets. We are going to speed this up. I would like to, First of all, if anybody had a problem hearing the background noise on that, let me know. But I'd like to point out that he is appropriately addressed. I personally would not have gone with the light colored blazer, but it's fine. He's appropriately dressed, and that works well for all the hearings. He wants to be appropriately addressed. You don't want to show up with some of them, looking scrungy, and in others looking well dressed, because that gives away what your attorney thinks is an important hearing, what your attorney thinks isn't. And you never know if you're going to be seen. Like, you never know if a juror will see this particular thing right here. John Clark says high school suit. I don't think so. I don't think so. It's not well tailored to fit him. You can see how it's bunching up on the back. It could just be he's sitting down. But he really should get a tailored suit, but he's appropriately dressed, and that's important. I don't think it's a high school suit.
You are unmuted.
So just judging from the posture, you can see that the attorney is very comfortable in this particular situation. I don't know if he anticipates what's coming up, but he's very comfortable in this particular situation. He's not stressed at all. Merry Christmas to you too, Top.
You are muted.
There was Earl. We're going to talk a little bit about Earl in this. Earl had this one suit that he bought. It was like a buy it direct off of the internet suit. It was fucking horrendous. It didn't fit. And I think it was GD who ended up finding the actual suit. It was like online. He found the suit. It was like $100 suit or something like that. It looked terrible. Earl thought he looked like $1 million. But yeah, people pick up like so Scissor says, is that a caution tape tie? He's saying that about the attorney. People pick up a lot of these little things. MSG says looks like a convict they brought to trial, kind of, because his suit jacket doesn't fit well, and so that's kind of what you're trying to avoid. You're trying to avoid in these particular things is having your client look out of place, look like people make a lot of judgments. People make a lot of judgments just off the way you dress. Because it is a Saturday, and because I'm bored, which is really why I'm streaming, I'm going to ramble a little bit. I remember I was not a suit guy until I became an attorney, and like the moment I became an attorney, I bought like 5 suits and a bunch of shirts and ties and all that fun stuff, and Men's Warehouse, baby. But I noticed that, in a tailored suit going out there, like, people treat you different. Chicks definitely treat you different. They notice, and they look at your shoes. They make sure, like, if your shoes are well maintained and clean and everything like that. Boy, that goes a long way for all you young men out there who want to catch a lady's eye. Wear a tailored suit. Doesn't have to be expensive. Men's Warehouse. Wear a tailored suit. Chicks will dig you, unless you're going for the bad boy kind of thing. In which case, well, then I guess you would wear a mesh shirt, leather pants, and a German helmet to court. So that's also a thing that you can do. Yes, because it's prejudicial. There's a lot of states will have rules on that. You can't make the defendant appear in prison garb because people will draw conclusions from it. That's the tie that was the caution tape tie, the statement on. There's going to be I think there's going to be some people in here who aren't going to be able to give an unbiased opinion. It's a okay tie. I personally wouldn't choose it. I would go for something a little bit more subtle. It as I think in something like this, I'd go a little more subtle. Maybe on the day when I'm doing the questioning, and maybe on closing comments, I would bust out a red tie or something like that. But I would go a little more subtle on something like this. So the crowd, I don't see anything outrageous in the crowd here. Let's take another look at the crowd. I think this side is probably the non-Turtleboy supporters, I'm guessing. Yes, he's very, very small. And you could probably see his penis. I don't know how big his penis is. Luckily, I haven't caught an uncensored video of his jerk off routine, but he does have a small body.
So just to let you know, you guys get cool. So we just have one still and one live. Okay, everyone come say David, all right?
Yeah, right. Like you're. So the army, the armed forces, they want you in a uniform. Why do they want you in a uniform? They want you in a uniform because they want you to conform. Schools will often have you wear a uniform, and because you get different behavior out of people. Stores, I remember when I was in sales, there was a dress code. You had to come in wearing a shirt and tie. The dress code was there for a reason. That wasn't necessarily for conformity, but they wanted you to project an image to the potential client, to the potential customer, of competence. And so a lot of these things are important. People are picking up on this stuff, but like when a defense attorney wears a red tie, he's usually trying to make a statement. A bold tie says that he's going after you, and people pick up on that. People pick costumes, even like day to day. People pick a costume. Like these people who came into court, they all came in dressed differently, but you could make assumptions about them based on the way they're dressed. Like this guy who came in wearing the hoodie and the jeans, like that's his costume. He doesn't. That's who he is as a person. He's probably he's not he's not gay, that's for sure. Well, it does get competence and professionalism at beating your wife. See, so Ralphie is going to be biased, and Ralphie's just coming in here to say negative things about Turtleboy. I mean, I don't like Turtleboy. It doesn't bother me, but it doesn't really add anything to the conversation, Ralphie. Yeah, you kind of tell. I mean, I picked that up. I also believe he is a turtle rider. He picked the wrong side, but you'll see a couple other turtle riders come in.
You're only allowed to take. Okay. Okay.
Well, I mean, it's a tad bit early. Uh, we've only seen the allegations at this point, Griffey, and well, I kind of treat myself like the court. I wait to see what evidence is presented. I don't I haven't watched any of his content, so I can't. Yes, she is definitely a turtle rider. I can't tell you who is going to win. I really can't. I don't. I don't know any of the background stuff. I've only seen the allegations, so I'm gonna have to wait and see. The allegations very damning. The fact that he went from what was it, 9 charges, 9 at roughly 2 years a pop. Now he's facing 16 at like 10 to 20 years a pop or something dumb. I mean, he's if he wasn't shitting a big brick, he should be shitting a big brick. Now the turtle rider making a statement. Look at him, sunglasses in court, making a statement. Look at this guy. What a boy. He sells it, doesn't he? And see, that's the thing. Like, is that guy really making you want police reform now? He's not. He's not. Yeah, but the difference is that on the complaint, he was limited to a maximum of 2 years a pop. Now his maximum on these are like 10 to 20 years. It is exponentially worse just because there was an indictment now and he is in superior court now. His potential exposure, his I'm going to call it liability, is through the fucking roof. Like he could potentially get the equivalent of a life sentence. He's in his 40s, I think. I mean, he could easily, if he gets 4 convictions, it's a life sentence. It's the essentially a life sentence if they do it consecutive, and they might not. They might do it concurrent, but you get the point. Like he could in theory spend the rest of his life in prison over what he thinks is a joke. Like he's not taking it seriously. He really should take it seriously. He's not, but what are you going to do? A Vegas bookie put the odds at even money at this point. Well, before I saw the prosecutor, I may well have thought that was bad. But now that I've seen the prosecutor, it doesn't really matter how good the case is. If the prosecutor is going to be fucking inept, well, that's bad for the state. You can't help it, internet god. It is a part of humanity. We judge people based on their appearance. It's baked in the cake. You can't help it. I can't help it. Good-looking people tend to make more money. Tall people tend to make more money. Both good-looking people and tall people tend to be more successful. You don't have to be good looking to like be a computer programmer, but the better looking you are, the more successful in general you're going to be. The better you dress, there's that old saying, dress for the job you want, not the job you have. And there's a reason for it. It's because it works. And you change when you put on a uniform. You, the individual, change. You basically judge yourself by your appearance. You take someone and you put them in a uniform, and they're going to, in general, behave differently than if they're wearing their normal street clothes. I haven't spent the last 10 years studying sociology like Chille has, but these are things I've picked up in my long, illustrious career of watching people. And the FBI has no power to drop these charges. Zero power to drop the charges. The FBI can arrest literally everyone. And the only thing that's going to happen is Massachusetts, somebody in Massachusetts will appoint a new special prosecutor, and it'll get put in front of a new judge, and the case will continue. that guy in blue said on camera that a guy's toddler deserved to have images of dildos edited in their face. Well, I don't think a toddler would understand. Would the toddler see those pictures? I'm sure that he thought that the guy who's the parent of the toddler deserved it, not the toddler, him or herself. And I'm sure it was like you're not gonna get me with the outrage. You're not gonna trigger me morally, Biff. Save it for someone. Save it for someone like who's that fat girl? Shiz. Save it for someone like Shiz. She'll care about something like that. She'll get all butt hurt and up in herself. Oh, how can you do that to the poor child? As if the child's gonna see the fucking image of them with a dildo edited onto it. Well, hello to you, Whale. Every tuber cartoon character has their Zaner. Was that Zane? I don't know who that guy was. I thought Zane was more in shape. It's neither a win nor a loss. He hasn't been convicted on the 20 years yet. I think his followers will continue to harass the people against him. Okay. Keeping him on social media is dangerous. Why? Is he going to say hurty words? Is he going to say hurty words? Are the words going to hurt? Is it a woman? This is California, bro. We don't ask those kinds of questions around here. The grand jury also thought at least some of what the prosecutor has, and they returned a true bill. That alone should demonstrate that he shouldn't be as confident as he is that he, quote, did nothing wrong, end quote. Well, so in order to have the criminal complaint issued, my understanding is in order to have the criminal complaint issued, you have to go in Massachusetts, you have to go in front of a magistrate, and it's basically like a probable cause hearing. You have to show probable cause in order for the criminal complaint to issue. That's my understanding. Now, I don't practice in Massachusetts, so take it all with a grain of salt. Maybe if the Massachusetts attorney, his name is Mark. I'm not going to say his last name, but if he wants to get up here and explain it or something like that, if he's watching, then great. But my understanding is that there has been prior to this a determination of probable cause by a judge. Now that it's doubled up, basically, now that a jury has found probable cause, there is the old saying that you could indict a ham sandwich, but that is a bit hyperbolic. Probable cause is a very low bar, but a grand jury saw the evidence that the prosecutor showed them. They haven't seen all of it, but they saw the evidence the prosecutor showed them, and they came to the conclusion that a crime was probably committed and that Turtleboy probably committed it. And that is true. The average IQ in prison is much lower than the average IQ in public. Well, that is very kind of you, Paul. Well, there you go. Good for you. Well, maybe he's slow playing it. Maybe he's putting a show on. Maybe he's trying to lure Turtleboy's attorney into a false sense of security. Maybe he was just unprepared for this particular thing, but he is going to be prepared for the actual trial. Who knows? That is precisely correct, Ralphie. The difference between sexual harassment and not sexual harassment is the looks of the guy who's talking to her. Exactly. You probably do. But at least you got rid of you got rid of your gay gamer chair. Kate is getting so wet over this. Well, you thought that, bro. So you think Kate is just as sexy as everyone else does. No real lawyer spends time doing this shit. Well, I hate to tell you this. I am a real lawyer. You can really look me up in the California State Bar. And this is the whole no true Scotsman fallacy, I guess. Tall and ugly with a little tallywhacker. Well, at least you're tall. It's the strange thing that he sees yesterday as a win, but forgets that he's there and awaits a worse punishment than before. Well, yeah. I get a jacket and slacks, but tying something tightly around your neck never made much sense to me. Well, I understand that. It's a uniform. It's a uniform. It tells people what you're about. It's a uniform. Like even something as simple as like shorts and a short sleeve shirt, right? That you can see someone in shorts and a short sleeve shirt, and you can tell that they're rich or that they're not rich by the style of shorts and short sleeve shirt that they wear. You can tell. I mean, it's a uniform. And by rich, I mean like long-term rich, probably came from rich parents, kind of rich. Grew up in upper middle class to lower upper class and above kind of range, and is currently in that kind of range. Yeah, if you commit a crime, you get charged again. No, this hearing shouldn't change the odds. Well, there you go. I mean, was that Mr. Medicare? There's the last Mr. Medicare stream. He started off with a guy shoving his hand. You don't actually see it, but a guy shoves his hand up another guy's butt with Crisco, and that's what you're making me think of. Paul Carroll, they also saw zero defense, and only stacking evidence of guilt. They can indict a ham sandwich again. Yes, but they saw zero exculpatory evidence. Yes, probably. You don't know that though. The prosecution doesn't have to show the exculpatory evidence, but you also have to understand that the state is most likely not going to waste time on a case where they know the other side is innocent, where they know it. I'm not saying it can't happen. It's not very likely to happen. And I get it. Turtleboy thinks that he's the target of some grand conspiracy or whatever. It doesn't make a lot of sense to me. I don't believe it. But because it seems like he's getting a pretty fair treatment so far. I believe every word you say. Well, sorry. Yeah, I can understand that. I mean, I can't understand being 5'8". I did one time though. See, I'm 6'2" and change. But one time I dated a gal who was like 6'3" or 6'4". I mean, she was, and she had no penis. So just so everybody's aware. But it was so weird not bending down to kiss a girl. That was so weird. Like, it's hard to do. And when she put on heels, she was like, maybe she was like 6 foot. And when she put on heels, she was like 6'2" or something like that. But it was like fucking weird. It was weird. Merry Christmas to you, Jay. Probably. There are some federal crimes that don't involve crossing state lines. But I'm not sure what the allegations are. So, because you got to remember 18 USC 241 and 242. Let's see. 18 USC 241. Share this tab instead. So this is a federal crime. You know it's a federal crime because it's in Title 18, which is crimes. If two or more persons conspire to injure, oppress, threaten, or intimidate any person in a state, territory, commonwealth, possession, or district in the free exercise or enjoyment of any right or privilege secured to them by the Constitution or laws of the United States, or because of his having so exercised the same, or yada, 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 they shall be fined under the title or imprisoned not more than 10 years or both. And if death results, blah, blah, blah. So no requirement of crossing state lines for a violation of 18 U.S.C. 241 or 242. 242 is 241 is the conspiracy, and 242 is, I believe, the actual deprivation of rights. So again, the FBI can be involved even if the crime does not cross a state line. Okay, fair enough. Fair enough. Uh-huh. Leave kids out of it. What? The kid isn't in it. He's not in it, Biff. I mean, in your head, you're putting the kid in it, but the kid's not in it. There's a photo that is allegedly going to be edited to have a dildo drawn on it. Like, grow up, dude. Like, perspective. Don't show the kid the photo with the dildo edited into it, and the kid won't be involved in it at all. Jesus. Well, I'm sorry. I will get right on to clutching my pearls. I talking about his case. The case will be his downfall. Probably. Well, no. So probably what he actually did will be his downfall. Him talking about his case. So I saw fucking Springer. I couldn't find it. He took down the live stream after he did it, but he was covering the allegations that the state or the defense was making in Springer versus 7th Judicial District Court, and he's going over these things, and he's saying all sorts of shit that like is essentially admitting to the things that they're claiming, like unknowingly. Like he's not figuring it out, but he's taking it down. So I assume he figured it out, or maybe his attorney saw it and they were like, "What the fuck are you doing, bro?" But yeah, like talking about it is just never a good idea. I decided to get promoted at work, spent a fortune on designer suits and nice houses, spent a lot of time in the CEO's office. He asked to see me and asked me to write a presentation work. Well, good. It like you dress for the job you want, not the job you have. Big baller award-winning journalist can't afford a good suit. Well, I don't know that he's prioritized it. Like, and it doesn't necessarily have to be a good suit. You don't have to spend like thousands of dollars on a suit. You could buy like a $500 suit and just have it tailored to fit you and look fine. Court TV maybe, and Long Crime Network are always looking for lawyers to be on panels for opinions. Send them your coverage on Chille. No thanks, not interested. Let the pearl clutching begin. You keep your deviant sexual practices to yourself, Whale. Well, he hasn't been convicted yet. I mean, I did not mean it that way. Because so this is a process I go through every time I get a complaint or a petition or whatever that I have to defend against. And my first reaction is, oh fuck, how am I going to defend against it? But then as I work with my client and we develop the facts, and I normally try to put everything into a timeline, that really helps. I'm a pretty linear thinker. Then okay, all right. And then I relax more and I figure out the holes in their case and everything like that. All we've seen so far is the complaint and the allegations. That's all we've seen. And maybe you've watched the videos and you've seen more, but that's all I've seen. So all I've seen is the complaint and the allegations. I haven't seen the complaint. I've seen the allegations and the indictments. It looks bad, but until I see what the defense is cooking with, then I can't make anything like an educated guess. The prosecutor was the gender-based question. Okay. Nice suits might be hurtful is finance. Simple, nice black, gray, navy, blue suits work well in that field. The classic thing is if you can only afford 2 suits, then you get one dark gray and one navy suit, and then you could mix and match the jackets. So like you wear the dark gray suit the first day, you wear the navy suit the second day, you wear one suit top with the other suit pants, the other suit top with the other suit pants, and then you go again. What works best is if you could add in a light gray suit into the mix, then you have 3 combinations, and that's like balling on a budget. That'll get you over a week's worth of suits for only 3. Oh wow, good for you. I am 100% correct. I'm always 100% correct. Yeah, he should not assume his charges are going to be dropped. And his First Amendment defense is incredibly weak. I mean, I'm a huge fan of free speech and everything, but his narrative that I'm a journalist and therefore I get to harass witnesses and tell them to change their story. Well, there you go. Okay. A call is for not to do a call to action. If I was TB's lawyer, I would tell him to shut up. Well, if I was TB's lawyer, I would tell him to shut up too. But there you go. If he actually does go on social media and do a quote call for action end quote, then the prosecution can take the appropriate steps. I am around men wearing very bright colors. Turtle needs a new suit. Well, it's good enough. It's good enough for today. The suit is god awful. I haven't. Is it a suit or is that just a blazer that he's wearing over a pair of slacks? I don't know. I just love when Team Fathead gets put in there. I don't know who Team Fathead is. Is he honey dicking them? That's a great question. I don't even know what that is. No, I did not. I don't like Turtleboy. He actually has a pretty good conviction record. You mean Mello? Mello's Mello does criminal defense and family law and personal injury. I'm gonna believe it when I see it. I would not bet on it. Okay. Turtleboy needs to get the exact same suit as Kodak Black had the last time he failed. I don't know who that is. Maybe you can start a newsletter. Maybe. Oh, I see what you did there. Because he's small, so he's going to be the bottom in prison. Flip-flops and cutoffs? Well, I mean, if you could rock it, you rock it. Nowadays, they have nice suits that feel like pajamas. Okay. Jay doesn't know the joys of autoerotic asphyxiation. I mean, I feel sorry for him. Well, thank you for not judging me, Vlad. Well, see, the thing is, like, I've seen people try to copy the style, but there's something about it. Like, if you're actually rich and it's part of you, you just wear it. Like, it doesn't. If you grow up in that style and you're comfortable in it and it's part of you, then you can wear it. If you don't, you look awkward in it. Like if you put a guy off the street into a suit. Now, it's great. The initial thought everybody would have would be like, oh, okay, he's wearing a suit. He's that professional class. But the mannerisms and the mode of speaking and addressing people and carrying himself and everything like that, it's going to be different. And it's not going to work. First class white trash. Okay. People with money buy nice stuff, but I see people that buy nice things, yet they file bankruptcy. Right. But see, here's the thing. Just because you file bankruptcy doesn't mean you're bankrupt. You can actually shelter quite a bit of money in bankruptcy, and it depends on the chapter 13 verse chapter 7 verse chapter 11 verse whatever. So, and like Donald Trump filed bankruptcy multiple times, but he filed bankruptcy on a specific business. So it wasn't Donald Trump saying Donald Trump is bankrupt. It was like Trump University saying that Trump University is bankrupt. Mr. Caruso. Still makes no sense. Life makes no sense. I don't think so. I think Paul Carroll works as DCSS. I think he works for the county trying to get them dollary dues out of deadbeat dads. Gifts to be placed in the happy birthday to you, orange cones. You beat sweet baby Jesus by 2 days, apparently. Merry Christmas, Nima. Mojito. Nice. Perception affects the odds. Little things like how attorneys present a point, facial expressions. Indeed, there is an art and a science. I do obviously go into court, right? I was in court yesterday morning. And thank you, Aaron. Like, I love the butthurt. Like, I don't give a shit what you think about my beard. And it's funny that you just want to hurt me so bad that like you're trying. And I kind of find it humorous that you think I'd like give a shit, but good luck on trying to affect me emotionally. Is Turtle talking all the time on? Is Turtle talking? Does that help him? If I'm the prosecutor, I want him to keep talking. I think him talking to his followers could cause him trouble. We've been over that. So yeah. 75% pro convict him. Convict him. Thank you, Nima. But you know what? I'm more concerned with what a dude who doesn't like me thinks about how I look. I want to take my fashion advice from a dude who doesn't like me. Because that's what everyone does. Thank you, Paul. It is the beard I was born with. We're supposed to be Mr. Caruso. Mr. Caruso. I just love saying that. Wow, someone's an anti-Christmas guy. Have you seen the junk beards being sold now that claim they look just like a real mermaid tail? Junk beads being sold now that claim they look just like a real mermaid tail in color? I have no idea what that. Yeah, I don't know. I'm sorry. Well, Ralphie, you're biased. You're biased. You, sir, are biased. Well, again, I hope you are. I hope you are. I don't want to see you wrongly convicted. And again, I don't like you, but I don't want to see you wrongly convicted. You know what? Now that Turtleboy's here, let's start this party. Let's keep watching this.
What's that, please?
You are unmuted.
Justices, number 6 on the list, Commonwealth versus AD, hearing 23 HCR 313. Can I counsel identify themselves for the record? Simon, come.
Okay, Mr. Miller.
Good afternoon, Your Honor. Timothy Braille on behalf of AD client. Here for the record. Okay, thank you for hearing us.
You know what we missed? We missed where Turtleboy was looking back to check for support. This is kind of what I wanted to discuss a little bit. So he's back checking support, given the victory little flash there and everything like that. This is we've seen this before. We have seen this before. And the place we saw this before was at the trial for Earl David Warden, right? I love tits. What are we talking about? We're talking about tits. I love tits. Tits are great. Well, we saw this at Earl's trial. Now, there is a lot of contention out there. The anti-Earl side says that Earl brought his supporters. and that he was trying to disrupt things and his supporters were trying to disrupt things. And the pro Earl side says that all these people came of their own volition, and Earl obviously isn't responsible for it. And at the end of the day, we ended up in a situation where anti-Earl people were apparently saying shit about Earl being this, that, and the other thing in the hallway in front of the jurors. You had pro-Earl people following jurors around, maybe to intimidate them, maybe not. But generally speaking, from both sides, you had a bunch of fucking assholes. You had a bunch of assholes. And that bunch of assholes took what should have been a clean and fair trial, where there would have been no doubt as to Earl's guilt or innocence, or not guilt, I should say, guilt or not guilt. And they turned it into a fucking circus. Now, Turtleboy might want that, but that's where this is going. If Turtleboy's got his people in there with their shirts, and they're making their little statements. This gal has fucking Turtleboy on her shirt. But this isn't a popularity contest. This is a place where the prosecution presents its best evidence, and the defense presents its best evidence or counters the evidence by the prosecution as best it can. And the jury should make their decision based solely on that evidence. Solely on that evidence. But you get people out here in the audience, in the peanut gallery, that are going to end up influencing the jury one way or another. It happened, at least my best guess, having read the motion by Earl's attorney and the opposition to that motion and the argument, and then the opening brief from Earl's attorney. It sounds like the spectators had an effect on the jury. So I don't, maybe Turtleboy wants to muddy it up so he gets a second trial. Maybe he does, maybe he doesn't. But it could also cost him. Like, it could literally cost him. I know Turtleboy thinks that he has a wide reach. But Turtleboy is a small fish in a very large pond. And the jurors who are going to be voir dired unless the prosecutor is a complete fuckwit. Unless the prosecutor is a complete fuckwit, those jurors are going to be voir dired as whether or not they watch Turtleboy or read his blog or anything like that. Which is going to narrow down the potential that people are going to like Turtleboy's actions. I mean, there is a group out there, there's a group out there that really likes auditors, right? And if you could get, for every auditor trial, if you can get a group of jurors who really like auditors, boy, smooth sailing. But most people don't. Most people don't like Turtleboy. I'm not saying this because I don't like Turtleboy. I'm saying this because if people liked Turtleboy, he would have a much larger audience. He would grow. He's been doing this for years. He's been trying to get his name out there. He wants people to know him. He's trying to be famous at this. Most people don't like that kind of shock jock sort of journalism. And he might be getting a lot of views, but you don't even know how many of those views are haters and everything like that. So the jury is most likely not going to be people who like his style of journalism, or the people who do his style of journalism things, right? This is much more likely to negatively impact Turtleboy's case than positively. And so what I'm saying is, if you are a Turtleboy supporter, I would recommend that you not go there and sabotage the case for Turtleboy. You might not think you are, but she probably thinks she's supporting him by wearing this fucking sweater. The dude in the blue, this guy thinks he's probably supporting him by wearing this shit. And if you're against him, again, don't go. Don't go. Earl might get a new trial because of Dougie the Crayon Bandit talking to jurors and saying things like Earl's a rapist or something like that in the hallway in their presence. You can fuck the case for either side or both sides. So my advice is to stay away. Don't look for I get it. You know, we're social creatures. We want to feel like we have a team, and we want to feel that support. You know, I'm not in this alone. I've got my people at my back. I understand. That's what Turtleboy wants. He wants that sense of reassurance. But you've got fucking idiots. You got fucking idiot. Like, this guy thought he was doing the right thing, and he's a fucking idiot. He looks like an idiot. And he's on Turtleboy's side. And so people are going to start connecting Turtleboy and this dude, and they're going to be like, well, this guy's a motherfucking idiot. You take Turtleboy out of suit, he's probably a fucking idiot too. So let's get this ball rolling.
Okay, Mr. Mills.
Good afternoon, Your Honor. Timothy Brito on behalf of Hayden County. Please give a vote for the record.
Okay,
Thank you for hearing us. Please be seated.
He doesn't look like a Fed. Just because he's wearing sunglasses doesn't make him look like a Fed. He's overweight, out of shape. He looks like a fucking idiot is what he looks like, not a Fed.
Okay.
I'm just trying to take a random there. See,
Yes.
sir, would you mind waiting until we get into that? Thank you. Come through, consideration of witness 9 through 13, 15, and 14 to 16 conspiracy. Mr. King, how do you wish to plead guilty or not? Thank you. Commissioner Bennett?
No. I think fine. Okay, and
So he pled not guilty. So awesome, right? That means we're going to trial.
I'll give you. There had been several conversations between defense counsel and I. Mr. Brito and I have actually got one quite well thus far. Anyway, and with respect to the timing of this arraignment, I'd like to record this as a public comment that we had represented to the defense that the arraignment would not take place until after the Christmas holiday. It was advanced to today, Your Honor, because Mr. Brito will be away, and we're looking to accommodate that schedule. So I would like that to the record reflect that's the reason it's being held when it's being held.
Sure.
In terms of
We were open for business next week, and we were prepared to do it next week, but I understood Mr. Brito was going to be away.
Judge, obviously this proceeding today is not being held in a vacuum. Your Honor has heard the facts of the cases that gave rise to the indictments appearing before you today. Unless Your Honor wants a summary, I will not repeat them. It's certainly been discussed publicly in this court before Your Honor.
Right.
To save.
I don't need a summary. What are you suggesting as conditions?
Your Honor, we're looking for stayaways again. One of the problems we've had, Judge, and I spoke to Mr. Brito about this several times, the defendant has, in the Commonwealth's opinion, continued to violate the original conditions of bail, including those that were implemented by Your Honor. If Your Honor.
Well, I hate to break this to you, San Antonio news, but Kate's fans aren't the brightest either.
Were to look at the video provided Mr. Brito has received a copy as well, the thumb drive. It's clear that Mr. Carney is encouraging his minions, his followers, in the context of his blogs and YouTubes, etc., to continue to harass witnesses. He made a statement such as, "I can't do this, and I'm not telling you to do this, but you can do this, but I'm not saying you can't do this. Don't put words in my mouth. You know, read between the lines. Read between the lines on approaching these witnesses." And he's made similar statements several times. It's the Commonwealth's contention that this is a very disingenuous way that the defendant is indirectly encouraging others to indirectly harass these witnesses and to intimidate these people. And
I disavow every single fan or follower. I don't want them. I don't like them normally.
take it in front of their homes, etc.
So what he's talking about is Aiden is apparently allegedly been suggesting that that his followers, that his turtle riders or whatever that you want to call them, are should go out and try to affect the jury pool. One of the allegations was that Aiden was supporting his or put up a sign, a billboard, trying to make sure that all of the potential jurors know about Karen Reed. I think it's Karen Reed, the Karen Reed case, and essentially he's trying to taint the entire jury pool. The I don't expect it's going to work. The number of turtle riders that Aiden has is fairly small. He managed to get a couple hundred people allegedly to do his little drive-by thingy around to the various witnesses' houses. When you think about the percentage of a county's population that 200 people would be, it's very small. It's not even a 1% of a county, I would guess. And I would also doubt seriously that all of Turtleboy's fans are drawn from the same county. The Newport 100 convoy, nice. I didn't know it had a name. But trying to affect the jury pool and or to intimidate the witnesses, the same witnesses for the Karen Reed case that he tried to intimidate are now the victims in his case. So him sending his people out to intimidate those people, it is literally just inviting more charges. And I don't understand why allegedly Aiden is so stupid, allegedly, that he would say things like, I'm not telling you to do it, or something like that. And then like we've gone through this with the auditor saying, I'm not telling you to call flood, but here's the number if you want to express your opinion. That was one of the things that Freeman was going over. Oh, I didn't go there with this guy. He just showed up. He saw my live stream and showed up on his own. I didn't encourage him to do it. Believe it or not, attorneys and judges aren't stupid. We figure out pretty quickly what you're actually doing. So it's not smart. You shouldn't do it. You shouldn't mention the victims of your alleged crimes. You shouldn't mention the witnesses in the Karen Reed case. You shouldn't do it. I know you're gonna, because you're smarter than I am. You're smarter than everybody is. You're the smartest guy in the world, Aiden. # sarcasm. But you shouldn't.
What I can represent, Your Honor, is that we had the grand jury proceedings underway. The Commonwealth was aware that most likely this matter would be before Your Honor or before the Superior Court in relatively short order. We did not proceed with bail revocation in the District Court. However, I can assure Your Honor, and would like the defendant to be on notice, that there's one more instance where he is online suggesting to people or encouraging people, either directly, disingenuously, or whatever the case may be, and encouraging somebody to read between the lines, that we will be back before the court seeking a bail revocation as well as a dangerousness hearing. I would ask Your Honor to fashion some type of order that Your Honor believes would be effective in including this defendant.
Turtleboy should not mention them. It's still early. You shouldn't be too drunk. Turtleboy should not mention them. Turtleboy is the one who's being charged with witness intimidation and conspiracy to intimidate witnesses. Turtleboy should not. So now the witnesses are his alleged victims. I know you were asking for clarification, and it was, I don't know why, because I don't think anybody else could have fucking failed to follow the bouncing ball. Jesus Christ.
From going online and encouraging his followers to essentially continue his pattern of intimidation.
What specifically are you asking me to order?
Judge,
You're asking me to write it.
I don't know. I've never moved from first-year family attorney to second year. Apparently Mello's a 39-year family law attorney, though.
I'm sorry? What do you want me to say?
Well, that you should not encourage and intimidate directly or indirectly to have his supporters or encourage his supporters to approach witnesses.
That's what the district court said. You have to stay away and have no contact with the witnesses directly or indirectly.
Or I think perhaps language that prohibits him from encouraging others to do so. Judge,
What he's asking for here is prior restraint. Now, it could potentially be worded in such a way as to be specific enough that it might pass constitutional scrutiny. The odds of this chowderhead right here being able to articulate something specific enough that it would pass constitutional scrutiny is somewhere in the slim to none range. Well, I don't know if that's a good thing or a bad thing, Jeff. I guess it depends on how fast they pull out the anal beads, right?
may come as far as not even mentioning the names of the victims that appear here. I certainly understand.
Well, it's good advice that he doesn't mention the names of the victims, alleged victims. But man, how could that pass constitutional scrutiny? How could that be narrowly tailored enough to not pass constitutional scrutiny? I don't know the name of the victim. Let's say one of the victims' name is like it's Albert, I think, is one of the victims, right? Let's say his last name, he owns a pizza place, so let's say it's Albert Stromboli. If the judge said you can't say Albert Stromboli, then that would probably not be specific enough, because what if there's another Albert out there? What if there's another person with the last name of Stromboli out there? What if there's someone out there by the name of Albert Stromboli? What if Turtleboy just says Albert? What if Turtleboy just says Stromboli? I mean, prior restraint is one of those things where almost always, except in relationship to like domestic violence restraining order, emergency protective order, civil harassment restraining order, things like that, it's almost always not going to fly. Now, in this particular case, because there is an allegation that Turtleboy had actually harassed these people, it might pass constitutional scrutiny. But then there's the problem that we're going to run into where there's no authority. The court doesn't have the jurisdiction, or at least is unaware of the jurisdiction, to make that order.
Understand that there are First Amendment arguments that are being made, and we're extremely sensitive to that. We're extremely sensitive to the fact that the defendant claims to be a journalist covering the case involving Karen Reed. We're aware of all of those things. However, the lines blur, the lines cross, and he is hiding behind the guise of a journalist, encouraging basically as an activist.
How do you hide behind the guise of a journalist? And he literally claimed he wasn't. He literally compared himself to Martin Luther King Jr. He compared himself to activists. He said, I am a journalist and I am doing activism. Okay, hands down. Shiz looks like a sack full of used baby diapers. And are like, normally fat chicks get big tits. Normally. That's the only way that life is even close to fair, is if as a chick gets fatter, her tits get bigger. That did not work for Shiz. Kate's got some nice tits. So definitely Kate, hands down.
And when he's doing so, that's what we're going to ask Your Honor to preclude him from doing, and perhaps preclude him from mentioning the names of these particular witnesses in a context that would encourage others to approach them or communicate with them. I know it's very difficult. It's if you see it, you know what it is, but it's very difficult to define it. And I think it's extremely disingenuous of the defense.
I second this. Page, please send Bob's for research purposes.
To say he's not engaging in it.
If you want to send Vegana, that's fine too.
Hold on one second.
And see, this is another thing. You've got people out there with their phones going off. I think it happens twice through this. That's not good. It's not good. The jurors will associate these things with Turtleboy negatively. We've already seen it play out.
I think it's extremely disingenuous of this defendant to say, I'm not encouraging this, when he's using terms such as read between the lines, okay?
James Freeman is your man. Chille is cool, but who is Turtleboy? Turtleboy is Aiden Carney. He is a blogger, like a shock blogger out of Massachusetts, who most likely, even though they both don't admit to it, most likely fucked Kate. She most likely really enjoyed it and is now fixated on him. And the two of them just constantly go at each other's throats. That's most likely what happened. Because I've never seen a woman so fixated on a guy like Kate is fixated on Turtleboy if she hasn't fucked him. Now,
All right, Mr. Bradle.
Thank you very much, Your Honor. We would just maintain our objections that we've earlier made before the court as to stay away orders on probable cause, First Amendment due process grounds, as that you just maintain that for the record in terms of our objection. As to any prior restraint on Mr. Carney's speech, counsel for the Commonwealth is having trouble articulating it because it's such a problematic area. I think that, how are you going to do this? Mr. Carney.
I want to point something out here. Something that nobody but me has, and I haven't said anything to this point because I wanted to see if anybody else noticed it. Because it's easy to pick on Mello, right? Mello looks like a sack of shit. He talks dumb. He acts dumb. He argues like a family law attorney. And there's nothing fucking worse than a family law attorney making an argument. Okay? This guy's talking about his objections. And he's talking about, prior restraint. I will bet you a shiny, brand new US nickel, freshly minted, that this guy did not notice anything or say anything about the jurisdictional issues that the judge is going to bring up. I will bet you anything up to a nickel that this attorney did not fucking know the same. Both attorneys fucking failed on this. Because if there was a jurisdictional issue, the very first thing this fucker should have said was, Your Honor, the court does not have jurisdiction to place restraining orders on my client if my client is released on recognizance. Sounds like you'd be good in bed.
The First
Sounds like
Amendment
you'd be
right
great in
to
bed.
encourage people to exercise their First Amendment rights. I've advised my client about the notion of indirect contact. When you tell someone to contact someone you can't contact on your behalf, that's indirect contact. He can tell people under the First Amendment to, he can share his views with his readers or his viewers, and they can do what they want. He's allowed to encourage them to speak out against what he sees as corruption, what he sees as.
Now, I wouldn't have known to argue the jurisdictional issue, but I'm not an attorney in Massachusetts.
As mismanagement of the Reed case, etc. I've advised him about the notion of indirect contact. We have a disagreement, counsel and I, a respectful disagreement apparently about.
Did he have to have known? Did he? Did he have to have known? Because if he knew, that's his strongest argument. The strongest argument is, Your Honor, the court doesn't have jurisdiction to issue this order. You don't have to get into any Reed-style questions about whether or not it's prior restraint, whether or not it's narrowly tailored sufficiently to pass constitutional questions. It's, Your Honor, you don't have the authority to make this order. If he knew it, he would have argued it. That is my assumption. Yes, they both have denied it, but it's the only thing that makes sense. The only thing that makes sense is it. I mean, because Turtleboy's fucked a bunch of bitches. Now He's never fucked one as ugly as Kate, but in Kate's defense, she has a kind of dirty sexiness to her that, you know, um, like a moped, fun to ride. You just wouldn't want your friends to see you on it. Bradel objected at least. Paige, like, simp fucking harder. He made the wrong objection. His objection didn't prevail because he made the wrong one, because he ignored the right objection, or he didn't know the right objection. He objected at least. At least he tried. You're so fucking pathetic.
What constitutes violating these orders? These orders are, in effect, prior restraints on his First Amendment activity, Your Honor. So they must be narrowly tailored and strictly construed. And in this case, we've discussed it.
He would have, but he wouldn't have understood it. He would have been talking some combination of subject matter jurisdiction over him, personal jurisdiction over him, and territorial jurisdiction over him. You wouldn't have known which one he was arguing, but it would have been one of the. He's fucking retarded.
My client, and I think we know as best we can what can and can't be done in terms of speaking out. That's not harassment. That's not witness intimidation.
Oh yeah, Teresa still maintains that she never fucked Earl. She still maintains it. But come on, dude. They went on a cross-country trip together. Like they boned. Like they fucking boned. And Teresa Richard is fucking fixated on Earl. Fixated on him. There is no way she did not fuck Earl.
That's journalism, and it's cloaked by the First Amendment, Your Honor. So I would object to any attempt to sort of craft.
Yes, he should have. But the defense also should have said, I'm objecting to these conditions, Your Honor, because the court doesn't have jurisdiction over that kind of subject. The court doesn't have the jurisdiction to make those orders. Bullshit. And he said, no, we object. And then he argues First Amendment issues, Paige. You dumb shit. He doesn't say, the statutes don't authorize the court to do that. The court doesn't have jurisdiction to do that. Did he say that, Paige? No, he didn't. No, he didn't. You know why? Because he didn't fucking think about it.
Have to fire restraint here, Your Honor.
If you didn't have big tits, Paige, you'd be nowhere in life. Big tits are your only saving grace. If your body had expended 1/10 of the energy into building up your brain as it spent into building up your tits, you'd be a genius.
And we'd object to any sort of effort in that regard.
All right, your client consents to the stay away, no contact, direct or indirect, with the various victims.
We don't, Your Honor.
No.
We object for the record.
You object?
Yep.
All right, Mr. Mello, under what statute do I have the authority?
Hold on a second. Let's go back to that, just so Paige can hear it.
We object to any sort of effort in that regard.
All right, your client consents to the stay away, no contact, direct or indirect, with the various victims.
We don't, Your Honor.
No.
We object for the record.
You object?
Yep.
All right, Mr. Mello, under what statute do I have the authority to compel Mr. Kearney to stay away and have no contact with the victims?
Well, Your Honor, it's common practice, as Your Honor.
I'm not talking about common practice, Mr. Mello. I'm talking about what statute authorizes me. This is not a district court proceeding, which is subject to Section 58 of Chapter 276. This is a proceeding under Section 57 of Chapter 276, or I have authority under Section 87 of Chapter 276 to impose conditions with consent. You don't have to ask for personal cognizance. You can ask for bail. You can ask for dangerousness if you think that's appropriate. But under what statute do I have the authority to set conditions to which Mr. Kearney does not consent?
I believe that, well, obviously, Your Honor, you would have to sign the terms and conditions of bail. We could do that through the context of a dangerousness area, which the Commonwealth prefers not to employ at this point in time.
You haven't moved for dangerousness.
I'm sorry?
You haven't moved for dangerousness. You haven't invoked 58A.
Right, we have not.
Right. So what statute authorizes me, absent Section 58A, to impose conditions on Mr. Kearney's release, if you're asking or consenting to personal cognizance?
I think.
Or even if you're stipulating to a particular bail. Section 87 is different than Section 57 is different than Section 58.
I understand that, Your Honor. I think in total, both sections 57 and 50 would give Your Honor the authority to impose certain conditions, especially when it comes to the witnesses. What I think the challenge here, Judge, is we have competing interests in each other. We have a competing interest of claim of journalism and personal.
Section, you said 57 and 58 together give the court authority. Section 58 applies to the district court, right? And section 57 applies to the superior court, right? And 58 has a provision in it that says, if the judge, I'm going to paraphrase now, of the district court determines it to be necessary, the defendant may be ordered to abide by specified restrictions on his personal associations or conduct. I quote that now to you in section 58. I quoted it before in my earlier decision, right? Section 57 has no such provision, right?
No, Jimmy Penrose. He is not a district attorney. He is a special prosecutor. He has 39 years of experience in criminal law, divorce, which is family law, DUI and DWI, which is criminal law, family law, which is family law, and personal injury. So he has 3 areas of practice: criminal law, primarily DUI and DWI, family law, primarily divorce, and personal injury. Additional practice area, car accidents, that's personal injury. So my best guess is that he has done defense work in criminal matters, but I have not seen anywhere where he has been a prosecutor. No, it is in like 1.5 times speed, but they're from Massachusetts, so they talk really fast. No, they're from Massachusetts.
I would argue, Your Honor, that although it indicates the district court judge may do it, certainly comes under the purview of the superior court. I don't think the intent of the legislature.
I don't know. He's also been. Here's another fun one. He's been sanctioned at least twice. Kenneth Mello, Mass. Attorney. And let's see if we can't find it. There we go. See if that loads. All right, so in 2016, matter of Kenneth S. Mello. As set forth below, respondent received a public reprimand for neglecting the interests of 2 clients in unrelated matters. In the first case, the respondent was retained by a client to file and prosecute a personal injury action. Over the next 3 years, the respondent performed very little work of substance on the case. With the statute of limitations looming, he did file a complaint in the Superior Court. However, a judgment nisi followed because the complaint failed to allege damages in excess of $25,000 as required by the Massachusetts General Laws, Chapter 212, Section 3. The respondent did not advise his client of the judgment nisi or take any other action in response to it. As a result, the lawsuit was dismissed without prejudice. The respondent never informed his client of the dismissal. The client ultimately contacted the court on her own and learned of the dismissal for the first time. In summary, the respondent's incompetent representation of his client, his failure to pursue the lawsuit resulting in its dismissal, and his failure to inform his client of the dismissal violated Massachusetts rules of professional conduct. Those. In the second case, the respondent was retained by a client to represent him in a criminal matter pending against him in the Superior Court. The matter went to trial, after which the client was convicted and sentenced to prison. The respondent timely advised the client of his possible appellate options. He also informed the client that he needed to obtain new counsel for any appeal. He did not, however, return the client's file in order to enable him to pursue the appeal himself or retain other counsel. The respondent also failed to file a notice of appeal for the client or to withdraw from the case, contrary to the requirements of Rule 65 of the Superior Court, which provides the defendant's counsel in a criminal case that has gone to trial is responsible for perfecting and prosecuting the appeal unless counsel is relieved of the responsibility after a hearing on a motion to withdraw. The client later demanded the return of his files, but the respondent did not comply until bar counsel opened an investigation into the issue. So the client said, "Give me my file back so I can appeal." And he said, "No." And he continued to say no until the state bar started investigating. In summary, the respondent's failure to file a notice of appeal or alternatively obtain the allowance of a motion to withdraw, and B, promptly return his client's files, violated those rules of professional conduct. The respondent's misconduct in the above cases was aggravated by the fact they received an admonition in 2006 for similar misconduct, Specifically, he failed to prosecute a client's case, resulting in its dismissal, and failed to communicate with his client. So I have, all right, well, let's check that out. Discord. Let's see what we got. If the Commonwealth had kept my case in district court, the stay away orders would still be in place. Instead, they got greedy and indicted me in Superior Court, not realizing that Rule 57 prevents. We were prepared to fight them, but it turns out we didn't have to. I don't think it says what you think it says, but I still believe that he didn't know. He would have argued. That would have been top out of his mouth. First thing, Your Honor, the court doesn't have jurisdiction. That would have been the first thing. So he's a special prosecutor because apparently there was a conflict in the prosecutor's office in this particular county of Massachusetts. So they got an outside counsel to do it. Why they went with him is anybody's fucking guess.
Was to narrow the authority of this particular court and make it less than that of the district court. It's normally that these matters are instituted in the district court before they arrive at Your Honor's level. And I believe that's why the legislature perhaps put that language in, but I don't believe it precludes this court from doing so either.
I have a suit that is very similar to that particular pattern. I don't know why they pick the particular fabrics they do for suits, but that's not an uncommon one. I don't wear that particular suit for anything other than hearings and going out. Like I'll go out in that suit like it's a little bit lighter blue than this one. It's a nice daytime suit, but hearings I wouldn't do a trial or anything really where I could prejudice a jury against my client in it. Why were they prepared to fight if they didn't have to? Well, you never know. You never know if your particular argument's going to carry a day. Judges sometimes make mistakes. That's why there are courts of appeal. So what a prepared attorney would have done, who was aware of that particular situation, would have made all of the arguments. That attorney made a lot of arguments. He just didn't make any argument about this particular issue, about the jurisdictional issue. So what he should have done is he should have led with the jurisdictional issue, and then he would have worked his way down from the most likely to succeed to the least likely to succeed arguments. He would have made all of them. It's the spaghetti method. You don't leave an argument on the table. You make all of your arguments. If you're not aware of it, you don't make it. Well, I think I'm right too.
A case that says that? I mean, the statutes are different.
I wasn't expecting.
You came in asking me to set a set of release conditions that you knew Mr. Kearney wasn't going to consent to. He objected to it before in the district court.
Judge,
I think.
I don't think Aiden's attorney looks like. I think Aiden's attorney looks. I mean, I'm not gay or anything, unless I am, but he's for a gentleman his age. He's not bad looking. He's appropriately dressed. I wouldn't have picked the tie, but it's not outside of the realm of acceptable. I don't know why. I get it. You don't like Aiden, but it's fucking stupid. It's stupid, Vlad. What you said, it made you look stupid. Like, I'm sorry. You look like a fucking retard saying shit like that.
I don't believe it precludes this court from doing so either.
You have a case that says that? I mean, the
I don't
statutes are
think-
different.
I wasn't expecting.
You came in asking me to set a set of release conditions that you knew Mr. Kearney wasn't going to consent to. He objected to it before in the district.
So that's the problem. This attorney knew that Aiden wasn't going to agree to them, and so the very first thing that you do, like in a complaint, like one of the first things you plead is jurisdiction. You say the court has jurisdiction because the facts happened in this county, whatever. You plead jurisdiction. The 100% Mello should have said, Your Honor, based on this section of the criminal code or whatever they call it in Massachusetts, we are asking for this. If the court said, well, are you sure that one says that I could do that? He should have been, yes, Your Honor, see this case, and this case. And then all of a sudden, Aiden's attorney would have been the one sputtering and making family law arguments because then the burden would have been on Aiden's attorney. And Aiden's attorney would have been woefully unprepared for it, as we already saw. You'd have to ask her.
Court.
Judge,
I think the district court was entirely within its power to set that condition, and it was appropriate for me to uphold that condition. I think it's an appropriate condition to be imposed in this case, in the Superior Court, but I don't know if I have the power.
Freedom is highly underrated. Most people pick security over freedom, and it has never done well. If you pick security over freedom, you lose both security and freedom.
To do it under the statutes, and I'm looking for some authority that you might have indicating that I have the power to do it.
what I would ask Your Honor to order is that he comply with all laws. Make the general provisions on some.
See, this is Mello sputtering and trying to get something. Order him to comply with all laws. Why the fuck would you order someone to comply with all laws? There's already penalties in place for violating
Someone's
that.
released on bail. The Commonwealth will take it from there.
If he's released on bail, he doesn't have to sign anything with respect to personal recognizance, right?
No.
You're asking me to release him on his personal recognizance, right? You're not asking for me to set bail, and you're not giving me any authority to indicate that I have a
Last I checked, no.
right or the power to impose conditions on his release.
I would suggest a dollar bail, Judge, if that's.
Well, excuse me for a second. I have the power to impose conditions of release under Section 87.
I would suggest a dollar bail, Your Honor. You haven't asked. I'm a monarchist. I haven't asked for bail, but now I've asked for OR, but now because all of a sudden I realize that I'm fucked and I'm not going to get the OR orders, the stay away, no contact orders. Now I'm going to ask for a dollar bail,
Including stay away, no contact orders with the defendant's consent, right?
Understood.
Okay. So
I mean, I realize I got to appear before Your Honor asking for a high bail, which I don't believe the Commonwealth would be honest to do. We don't expect Mr. Kearney to.
You build 100 bridges, but do they call you Merv the bridge builder? No, they don't. You mend 100 fences, but do they call you Merv the fence mender? No, they don't. But you suck one dick.
And not appear, at least at this point in time. The normal condition of release, Judge, would be that he comply with all statutes. If Your Honor.
No, he's not an idiot. No, cat paws. No. He is entirely unprepared. He walked into this thinking that he was just going to argue equity, that nobody was going to question whether or not the court had the power to make the order. The thought never fucking crossed his fat mind. If the thought had crossed his mind, then he probably would have done the research, and he probably would have come up with a better answer or a better argument. Or maybe he would have asked for actual bail, which could come with conditions instead of OR. I'm more like building Eiffel Towers. Oh, God.
Not inclined at this point in time to fashion an order. The Commonwealth certainly appreciates the court's position.
I don't have to order him not to commit crimes. If he commits another crime, he'll be in front of the court on a violation notice. I don't have to order that. He's already subject to the law as everybody else is.
We would indicate that's an indirect violation, and we would proceed back to court, Judge. I'll accept Your Honor's ruling.
Okay?
Nope. Nope. Those other charges were dismissed without prejudice. That's how they bring these charges. You can't go to court. You can't proceed in two courts for the same crimes. They've got to drop them in one so they can have them in the other. So no, the bond conditions in the district court are not in effect anymore. I don't know what we're talking about there.
Anything further, Mr. Bradle?
Nothing further, Your Honor. Thank you.
All right. All right. I'm going to, on the Commonwealth's recommendation, release Mr. Kearney on personal recognizance. The Commonwealth not now looking for bail. I do find that the Commonwealth has asked for conditions to be set on Mr. Kearney's release, but the Commonwealth provides me with no authority that I have the power to do that over Mr. Kearney's objection. The statutes are a little bit convoluted. General Laws 276, Section 87 allows me to set conditions on release if the defendant consents to those conditions. Here, Mr. Kearney doesn't consent to those conditions, and the provision in Chapter 276, Section 58 Paragraph 1, last sentence, which I quoted before, authorizes the district court to set conditions on personal association or conduct, including avoiding all contact with an alleged victim of a crime. That provision does not appear in Section 57, which is the provision that applies in this case for the setting of bail in the Superior Court. And while that provision, Section 57, authorizes the setting of conditions in 209A and related type cases, this is not one of those enumerated in Section 57, which allows me to set conditions on Mr. Kearney's bail over his objection. This is a bail setting under the first paragraph of Section 57, which does not have the same language as in Section 58. So I am hamstrung, at least with the authority given to me by the Commonwealth. So I'm going to release Mr. Kearney on bail. He knows that if he commits a crime, he'll be back in front of the court in quick order. So you'll make sure of that, Mr. Mello, I'm sure. Anything else? We need a pretrial conference and a pretrial hearing date.
Well, that's really it. I guess we should probably switch our attention over to Castro versus the LV MPD. What do we have going on? Did we go over the motion to dismiss? Chat, did we go over the motion to dismiss already? I think I did. It's probably not worth it to go over the motion for reconsideration. Chille's going to lose on that. It's the same thing. You have to allege new facts, and by new facts I mean they can't be facts that you should have alleged at the original hearing, but they're facts that you could not have alleged at the original motion hearing because they weren't available to you through no fault of your own. Like if you'd already done discovery and the defense had failed to disclose certain facts to you, you file your motion gets denied, and then the defense discloses those facts to you, then perhaps you would be able to file a motion for reconsideration based on new facts. So that's one way you could do it. The other way is through new law. And new law literally means new law. Like if the day after your motion gets decided, then a superior court of some kind, like a court of appeals or a Supreme Court, makes a decision that would materially affect the way your hearing was decided, then that would be a valid motion for reconsideration based on new law. But you really need new facts or new law. Motions for reconsideration, generally speaking, fail. If you think the court made a mistake, it's going to be very hard for you to convince the court that the court made a mistake without showing that you failed to raise the matter of law. Like, because the court is going to look at the facts that you had and look at the law that you presented and make its determination. If it applies the facts that you gave it to the law that you gave it, and it comes out with a different thing, like, what are you going to do? You're going to say, well, you forgot about this case, Your Honor. Well, you didn't brief that case, so you're not going to prevail on it. What does that mean, Alerica? What does it mean that you support Chille? Like, if you think, like, is when you say I support Chille, do you agree with his opinion that Terry versus Ohio was improperly decided? Do you agree with him making an ass out of himself, yelling at the police? Do you agree with him inserting himself into traffic stops and other situations where perhaps the person who's been stopped doesn't want Chille to be intervening? Do you agree with him violating trespass laws in Ohio? Do you support him in his running out of Ohio in violation of an order to appear and thus incurring a bench warrant for his arrest out of Ohio? Is that something you support from him? The problem with supporting people and not ideas is that generally you're going to get fucked because there's no perfect person out there. Chille makes a lot of mistakes. Well, I don't see a response, and it doesn't appear that we're getting one. So fine. I mean, it's a free country, freedom of association. You can support whoever you want. But it doesn't make a lot of sense. It's like I think that Terry v. Ohio was improperly decided. I don't think that you should have a standard lower than the standard set in the Constitution for any stop. I also think that all the cases that allow lower constitutional protections at the border, lower constitutional protections for inland border control checkpoints, things like that. I think those are also violate the Constitution. But unlike Chille, I can actually make a argument for it. That's fucking terrible because his 5A cop card is garbage, and it will most likely get you into worse trouble. Alerica, you know he's not an attorney, right? And you know he hasn't actually studied constitutional law for 20 years, and you know he doesn't understand the law that he pretends he does. I mean, Alerica, you look like you have big tits, and from what you've been saying, you're probably great in bed, but oh, you're one of those. You like the bad boys because you think you okay. All right. One of the least fun things that I've ever had to do is go to jails, excuse me. Thankfully, I've never been to a prison, but I've had to go to jails to meet with various potential clients and things like that. And there's always these women out there who, good looking like Alerica, who are there waiting for their man to get out of jail. He's not. And you just know the life that they're in for, because they're fucking dumb as dog shit. Like, literally, I have scraped shit off the bottom of my shoe that's smarter than these women. And and yet they think that they can make them right, or they buy into the fucking sob story, or what have you. It's never the guy's fault. Well, I mean, they got me for bank robbing, but my mom was sick and I was trying to buy her medicine or whatever. Yada yada. Probably. I mean, there's always the, you know, the guy that you want and you can't have, but then there's the hot dick that you can have, right? You know what I'm talking about, Jeff, right? You know about that hot dick? You know what I'm saying, right? Uh-huh. I'm based. If you have to say you're based, you're not based. So anyway, show's going to lose on his motion for reconsideration. I don't think I need to cover it. And so we are going to move on. We're going to move on. I'm going to close some things. So, oh my God, it's like a caricature. You're like a caricature of all those women. Oh, Jesus. You know how it be, Jeff. So one of the things that you should probably never do is, if a court is trying to get you charged with criminal contempt, not the quasi criminal contempt that would just be like if you did something in front of the court, but actually like criminal charges for contempt. Let's pause and consider this for a minute. Let's just consider this statement. I believe in the nuclear family. She definitely has chest tattoos. Definitely has titty tattoos. Guaranteed. The titty tattoos right in there. Guaranteed. But what is the, like? I believe in the nuclear family. What the fuck does that even mean? I believe in the nuclear family. What, did they exist? Like, you're so airheaded and stupid that you say shit like this and you think you're saying something. Exactly, drunk Rob. Exactly. Oh yeah, definitely the tramp stamp. But the titty tattoos are going to be real. And probably like, I don't know, like a guy mowing a lawn right at the top of her fupa. I mean, it's got to be, right? You just like, she's just a caricature. Just a caricature of a real person. But anyway, you probably don't want to make videos about this. And like I said, there was a live stream he did, and I wish he had not deleted it. It was on this channel, and I checked his other channel too. It was on this channel, and it was amazing. Basically, he was making the defense's case for them. Ass antlers. Oh wow. It's so unusual that one man and woman raise a family together. That's what she believes in. Now, she doesn't have a man and she doesn't have a family. No. She's got to be a single mom. Got to be. Definitely single mom. Oh, you're right. You're right, John. I should learn the law before I make videos like this. John is also ass mad. Oh, John. Why don't you write me a memorandum of points and authorities on what I messed up, John? Why don't you go ahead and do that? I will actually, if you submit to me a memorandum of points and authorities, I will go over it on stream live and we'll work through it and we'll see how I screwed up. So this is your opportunity, John. This is your opportunity, sir. My email address is merb34st@gmail.com. Go ahead and send me that memorandum of points and authorities, and I'll read it. Yes, definitely horrible relationship with her dad. Well, Top, you have a lot of tats, but you also had that gay ass chair. That gay ass chair. Oh, here we go. Here we go. His videos are spot on. He'll run circles around you on points of the law. Oh, Jesus Christ. He was saying that oh shit. What was he saying about his attorney? It was fucking hilarious. He's like, he's a great attorney. He's hands down the best attorney in New Mexico. He sued the entire New Mexico Supreme Court. Now he lost, he got sanctioned for it. Because that's what good attorneys do. They fucking lose so bad they get sanctioned for it. Oh my God, you're a fucking retard, John. Again, you'll submit that memorandum of points and authorities. Hairstylist? Oh, I don't know. I think I would bet that she works in the medical field as like a dentist. What do they call those gals who work in a dentist's office? One of those. Dentist assistant? Whatever. That's what I think. CNA? Something like that. I'll bet she goes, I'll bet she wears those fucking, what do they call those, scrubs, and drives like a Range Rover. Not a Range Rover, that'd be too expensive. Something like a Jeep kind of SUV, and says things like, my son Aiden is my king. Nursing assistant for sure. Oh, I'll be right over. Yeah, we're angry. Are we angry? I wasn't angry. Dental technician. Thank you, Orange Cones. Thank you. That's what I was looking for. Dental technician. Oh no, James Freeman was actually right on that. Yeah, he can. He can. That's my analysis of the law. 100%. And as soon as the security guard that arrested him was no longer available to testify that Freeman's feet were on the base and they lost the trespassing part, that's why it got kicked. He 100%. You have the right to film a base from not off base property. Absolutely. First Amendment protected. Absolutely. Oh no, don't file a class action lawsuit against me. Oh no. You're a fucking idiot. Like what cause of action do they have? And it cost me $400 or whatever to, I mean, if they file in federal court, it'll cost me $400 to file a response. That's nothing. I can fucking do that. I'll file a response and I'll get it fucking booted. They're like, I'm like the tar baby or the brar rabbit. And I'm saying, oh no, please don't throw me in the brar patch. Like you're fucking threatening an attorney with a lawsuit. That's how stupid you are, dude. I'll still wait for that MPA. Dental hygienist, absolutely. Nissan Altima could. Ooh, yeah. Yes. Yes. Subaru. Maybe. I never, yeah. Oh, fucking, who's this? What's it sued me? Earl sued me. Yeah. I was super sweating that one. Well, you know, we all knew that you were disabled. Trust me. Imagine using military police as a legal point of reference. I don't know what that means. Anderson doesn't rule 23. Anderson doesn't rule 23. Is that the FRCP rule 23 that you're referencing there? She just describes some meaning to be in Aries. Don't really need to hear what else she finds profound after that. Yes. But I mean, come on. You admitted to something. Bravo. Like, is that directed to me? Like, I like James Freeman. I like James Freeman. He's wrong about a lot of stuff, but like fundamentally his core principles, I agree with. Like, our government is way too oppressive. Our systems are way too oppressive. And I agree with a lot of what he says. Now, he takes a lot of things too far, and he oversimplifies things. But he's, I agree. I agree with the fundamental liberty kinds of positions that he has. Well, I mean, you can sue anybody for anything. Hurt feelings led to lawsuits by Chille. You're wrong. Blue Bacon already proved you can't film a military base. He proved it, huh? Well, that's funny because if you go out and you watch auditor videos, there are a lot of auditors who have filmed a lot of military bases from off base. And you show me one that was convicted for it of filming a base, not of trespassing or anything like that, but of filming the base. 18 USC 750, whatever. 18 USC 7. Was it 793? 751? $795. 18 USC 795. Yeah, 18 USC 795. All right, there we go. So whatever the president defines as a vital naval or vital military naval installation or equipment. So there is a executive order that defines that. And then there are subsequent executive orders that rephrase it. So it used to be anything that was designated as confidential, secret, top secret. I think there's like 4 or 5 different ones. They've reduced the classification subsequently. So whatever he's designated that as, a military or naval installation is not the entire base. There's a definition for what the vital military and naval installations are. Basically, it has to be located within a post, fort, base, whatever. So when they're talking about a military, naval, or naval installation or equipment, that would be like an installation would be like a radar array. That would be something that's installed into the base. Otherwise, this would most likely be unconstitutional. But no, Blue Bacon didn't prove shit. Hell yeah. You take her to Applebee's and dude, you take Alerica to Applebee's and you get her like 2 mojitos. I'm guessing mojitos. And she would blow your fucking hair back. I don't know. It's Saturday. People have time to kill. Yeah, I know. I didn't think Subaru either, but it's some kind of SUV. Because, there you go. I don't think so. The Altima is pretty good. If it is a car, it's an Altima. But yeah, your mental disabilities probably don't prevent you from driving. Yeah, exactly. Nice. Yes. Yes. I don't care what Lyncher said. I can argue with Bacon supporters, and I do argue with Bacon supporters. It's already demonstrated how filming a military base is a violation of. No, he didn't. He literally didn't. He just asserted it multiple times. He didn't. I went through all of the executive orders. The initial one that where the president made the definitions and then gave the power to assign those classifications to the various people. I went over the subsequent executive orders that modified that initial executive order. And I explained how the constitutional analysis would go if it wasn't, because you have to remember, under a strict scrutiny analysis, which this would be subject to, it has to be the least restrictive alternative. And of course, the least restrictive alternative to prevent someone from filming a gate is to place it behind another gate. That's the least restrictive. So the analysis I went at, and the actual executive orders I went at, and being an attorney I went at, because Blue Bacon's a fucking tuba player, homie, and all of his assertions were, I talked to a JAG. I'm like, okay, fucking put the JAG up on the stream. Let me talk to the JAG. And they didn't do it. So yeah. I don't fucking know. This is stupid. And it's only 159 now. Yeah, I have not seen anyone convicted. Even there was a flurry for like a year or two of people filming gates. I don't know if Nasty Nate's in here, but Nasty Nate has filmed dozens of gates. He, in fact, if I remember correctly, while he was up with visiting with Blue Bacon, who I swear to you is gay, and I know Nate is too much of a gentleman to divulge it, but Nate had a wonderful time up there with Blue Bacon. But Nate up there filmed a base, and that's what broke off their friendship. Probably. I don't know. I haven't actually been talking a lot of law today. I think that's what he was trying to suggest. Or, you know what? You let him have his fetish. If he likes penis up his butt, then by God and by golly, he should have penis up his butt. And if you need a penis to go up your butt, you know my number. There are very few convictions for it. There was a Chinese spy who filmed things on base down in Florida. I forget the name of the base. But he was convicted of violating 18 USC 795. But he was filming on base. And then the other thing that they have is a civil suit for a violation of rights, 42 USC 1983 lawsuit, where a reporter stopped outside of a base and was filming the base from outside the base. Guard came up, interfered with it, took her camera, etc. And then the attorney on that one dropped the ball, and he chose not to argue, or he didn't essentially argue that 18 USC 795 didn't apply. And so because he didn't argue that, then the court found, because there was no opposition to it, that 18 USC 795 would apply to give him probable cause. Those are the two cases that Blue Bacon was able to find. Those are the same two cases I was able to find. Neither one of them shows that filming a military base from off base violates it. There is another one. It's like the next one, right? It is 797, I think. So 796, use of a aircraft for photographing defense installations. This one is where you're up in a plane doing it. So this one would anticipate you not being over the base. But again, it's the vital naval or military installations or equipment in violation of 795. So it's obviously intended like this would be off base, right? Or else they could have just said off base. It would be off base. Is kind of what I'm trying to say. They wouldn't need that if it applied off base. Nothing wrong with that. It is the weekend, tomato. Yeah, so on base, it's entirely different. On base, they can absolutely control what you film or don't film. Absolutely. Well, you probably get very dehydrated then. Yeah, high-end Toyota. Yeah. Oh, she drinks. Don't let her lie to you. I don't know. I know the Malinois make great police dogs. I'm not really familiar with the Dutch Shepherd. I don't know. I really like Anatolian Shepherds. They're really big though, but they're super like laid back. But you absolutely don't want to fuck with them. I don't know. I don't know. That wouldn't be an accurate statement. The reasonableness test only applies in certain situations. Alerica is, I mean, yeah. She looks like she has big titties too. Aw, we have a match. Better blue bacon than blue balls. Amen, sister. I don't know. They fuck. Oh, I assume so. I definitely assume so. Yeah. Blue bacon is gay as hell. Like, not that there's anything wrong with that. Watching the cop who told a lawyer driving a Uber that it's illegal to film police in North Carolina. Can the bootlickers defend that? Well, you let me know when you find out. Well, it's generally legal to film a military base for public property. Note that this can be subject to restrictions. Certainly, I mean, if it's a traditional public forum, it would be subject to reasonable time, place, and manner restrictions. Could be subject to reasonable time, place, and manner restrictions. But I mean, you'd really have to give me an example of what those restrictions are, and then we could do the constitutional analysis of it. 1-800 below 34th Street. Nice. All right, have fun, Top. No, there was a civil lawsuit against a I think it was against this. I think it was against the sheriff. The sheriff, yes, it was against the sheriff. The sheriff was called by the security at the base to enforce it. That's what it was. Sorry. Yeah, it was the sheriff. A Dutch Shepherd is I'm assuming that's Malinois in a brindle coat. Learn something new every day. Was it though? I don't think it was. But hello, baby. Most people aren't reasonable. That is true. Nice. A chick with no legs. She can't get away from you. Don't have anything to spread apart. Just in it to win it. How do you deal with the snail trails? Hell yeah. Everyone's picking up what she's putting down. You got feet? No legs, but you have feet? That's crazy. Crazy. Hell yeah. Nugget. Nugget. Oh, no. Surfith. Surfith is a special breed where he tries to make me defend things that I don't defend. I don't. He's been hanging around my channel since the beginning, and like, look, these cops got arrested. How do you defend them? I'm like, I fucking don't defend them. Like, anyway, we're all caught up. We're all caught up. So what do we got going on here? What do we have going on here? I don't want to do this, but we'll do it. We'll do it. Filming personnel, you could absolutely film personnel from public. Absolutely. Filming a secret installation on the base, that would probably be subject to 18 USC 795, because secret, I believe, is one of the classifications. Using high-powered telephoto equipment to record certain installations or equipment. Yes, just because. So if you are able to defeat essentially the defenses of the base by using like a high-powered telephoto lens or something like that, or an airplane, to film secret, top secret, class or whatever, those ones. Yes, that'd be 18 USC 795. But just filming the base itself doesn't get you there. All right, so this is the defendant's motion to dismiss the complaint. I'm going to skip a lot. Legal standard. They're going for a 12B6. They're alleging twickball. Twickball means you have to thank you, tomatoes. All right. When examining a complaint under Rule 12B6, court must determine sufficiency of the allegations within the four corners of the complaint. If taking those allegations as true, in doing so, the court should consider the complaint as a whole, along with the documents incorporated by reference into the complaint. Thus, the question that confronts the court is in a Rule 12B6 motion is not whether the plaintiff will ultimately prevail, but whether the allegations entitle the plaintiff to offer evidence to support his claim. However, court may also properly consider facts for which it may take judicial notice, such as those facts which are a matter of public record. Rule 12B4 and 12B5 allow a defendant to defend against a claim on the grounds of insufficiency of process and insufficiency of service of process. Failure to serve a defendant as prescribed by Federal Rules of Civil Procedure Rule 4 is a ground for dismissal under Federal Rules of Civil Procedure Rule 12B4. So these are the facts that they think it should be pinned at the top. Yeah, make sure you guys donate. There's a There's a link in that pinned comment. Everybody, make sure that you donate to my G-String account. Oh God, you know she is. And she swallows too, guaranteed. With like where like continues the suction even after you've nutted and it feels like your guts are coming out. One of those. So these are the facts that that they think are important, that the defendants think are important. At the beginning of 2023, the state of New Mexico had a mask mandate in effect for its courtrooms. A copy of the mask mandate or of the mask requirement sign is attached as Exhibit A. The 7th Judicial District Courthouses also posted 7th Judicial District Courthouses also posted signed notifying visitors the recording devices, including cell phones, are prohibited. A copy of the prohibited items sign is attached as Exhibit A to Exhibit A as Exhibit A-B. Again, they did not proofread these. On or about January 27, 2023, plaintiff entered a courtroom at the 7th Judicial District Court to observe a hearing before hearing officer Gordon Bennett. At this hearing, Bennett asked plaintiff to put on a mask, identify himself, and whether he was recording with a cell phone. Plaintiff refused to put on a mask to identify himself and confirmed that he was recording with a cell phone. H.O. Bennett warned plaintiff that if he continued his misconduct, he, assumingly Bennett, may charge plaintiff with contempt. Plaintiff left the courtroom, stating he would be back. Plaintiff posted videos of his interactions with Bennett on his YouTube channel. Plaintiff asked Torrance County Sheriff's Office whether they would be enforcing the mask mandate, who responded, "We're not going to enforce a mask mandate in the courtroom or anywhere else." Okay. On February 28th, 2023, Chief Judge Murphy entered an administrative order in the interest of the safety and security of its judges, special commissioners, hearing officers, and other court personnel. The administrative order further explained that plaintiff is an obstinate visitor, is banned from the Torrance County District Court unless appearing for a hearing or having specific court business, and must be escorted by the Torrance County Sheriff's Office while in the building. Nice. Nice. I'll let you put that together, Tony. You can market it. So just here's a real problem. Here's a real problem. Just that Bennett asked plaintiff to put on a mask, identify himself, and identify whether or not he was recording with a cell phone. And then Freeman posting the video of that interaction, confirming he was recording, confirming essentially that he wasn't wearing a mask, and confirming that he was a bit of a dick to Bennett, confirms that he was violating at least 2 court orders. So that's a problem. That's a problem. Can the court take steps to remedy a situation where someone is violating court orders, is made aware he's violating court orders, and then acts like an ass about when confronted by a judicial officer? Well, were those mask mandates legal? I don't want to talk about all mask mandates because I don't know about all mask mandates. The Supreme Court of New Mexico requiring people to wear masks as a condition of entry into their courts, I think most likely is legal because, number one, The Supreme Court of that state said that that's a requirement, and I don't believe that there is a constitutional question involved in it. Just like if the state Supreme Court said you have to wear a shirt to enter the courtroom, or you can't wear shorts in the courtroom. So my assumption is that there is no contradiction. There is no constitutional restriction or statutory restriction in New Mexico preventing it, because the state Supreme Court said it was okay. And I don't believe that there is any federal constitutional provision against it. I don't like it. I don't agree with it, but I can't say it's not legal. On March 1st, plaintiff received a letter notifying him that court staff were being harassed on his behalf and provided him with a copy of the administrative order. It was funny with when Freeman, when he was live streaming, he was talking about 95% of the people who were calling were perfectly pleasant, perfectly nice, tacitly admitting that like 5 to 10% of them were being complete assholes. God, like, I agree that most of there were a lot of things that were arguably unconstitutional that were done during those times, but that's a overbroad, or that's I don't recall the Constitution being suspended. When plaintiff visited the Torrance County Courthouse in March of 2023, the court clerk, Rosengal, asked plaintiff where his law enforcement escort was pursuant to the administrative order. Plaintiff responded, "Yeah, I'm pretty sure prostitution is illegal in New Mexico. I don't know if you're trying to solicit me right now, but I don't appreciate it. As a matter of fact, I think I'll head over to the sheriff's department right now and let them know you're trying to solicit me. Is that what you're doing?" Ms. Rosengal gave a copy of the administrative order to plaintiff, who remarked, "I don't know what sua sponte is. I don't know what that is. I think it's something to do with the hooker they're trying to have walk around the courthouse with me." No. No. I'm in California and no. How about no? How wrong can you be? How about all the wrong? If you're talking about like wiretapping, like if you're there, you could theoretically have issues with wiretapping in certain circumstances that I don't want to get into now, but just generally speaking, filming in public, it's just no. I mean, you could film people in public without their consent. So no, you're wrong. Plaintiff also entered the Moriarty Magistrate Court for non-court business. Court staff and personnel reported he was being disruptive and threatening in the courthouse. Specifically, plaintiff refused to identify himself or sign it, demanded that Judge Davis, quote, "get his bitch ass out here," end quote, and used expletives while addressing court staff. Yeah. The court amended the order to include the courthouses in Torrance County, Catrone County, Socorro County, and Sierra County. On April 24th, 2034, plaintiffs submitted an Inspection of Public Records Act requesting Judge Davis, or calling Judge Davis, quote, a man in a black dress, end quote, and Chief Judge Murphy a, quote, cunt, end quote. Plaintiff provided his request for a sample IPRA request on his YouTube channel. So he showed everybody what his request was. On May 18th, 2023, plaintiff was removed from a hearing over which Chief Judge Murphy was presiding. Plaintiff was removed due to his previous harassment of court judges and staff, as well as for recording court proceedings in violation of Rule 23-107 and MRA and reposting edited versions on his YouTube channel. I don't recall that. She smokes pot. Who would have thunk it? Oh, it was a typo. It was a typo, she says. On May 24th, 2023, Judge Murdoch Poff entered an order excluding presence in a specific cause, looks like a domestic violence cause, citing that Mr. Springer was still banned from the Torrance County Courthouse and specifically banning him from the hearing. Due to plaintiff's continued refusal to follow court rules orders, Due to plaintiff's continued refusal to follow court rules orders, the 7th Judicial District Court sent plaintiff a notice of order to show cause hearing set for June 16th, 2023. A copy of the notice is attached here to as Exhibit E. A week before the hearing, plaintiff filed the present complaint. Because they were named as defendants in this matter, Chief Judge Mercedes Murphy and Judge Shannon Murdoch Poff recused themselves from the state court proceedings. On June 9, 2023, plaintiff filed his complaint. On November 27, 2023, plaintiff then filed his amended complaint. Plaintiff's complaint, why are we talking about his complaint? I don't know. We should be talking about his amended complaint. Plaintiff's complaint named the 7th Judicial District Court, Chief Judge Mercedes Murphy, Ms. Rosengall, Judge Shannon Murdoch Poff, who you've already identified Judge Shannon Murdoch Poff, and now here you are again doing that. And why is there the extra hyphen between Shannon and Murdoch? I hate these attorneys in this case. You want my dick? I know it. Show me them titties. We'll talk about it. The court noted that plaintiff asserts that he provided notice through email to the 7th Judicial District Court's proposed text email and ordered plaintiff shall serve the complainant summons, a TRO motion, and this order on the appropriate defendants. Plaintiff filed summons returns for the 7th Judicial District Court, alleging service through Susan Rosengall on June 9, 2023. Summons returns for Jason Jones. Mr. Jones. They've already identified Susan Rosengall as Ms. Rosengall previously. They already see there's Miss Rosengall right there. So normally the way this works is the easy way. This is the way I do it. I figure out what I'm going to call the people, because you do these things like you might type up this as 18, but then it might move up and down the list, right? So you don't necessarily know when you're starting what is going to be the first one of these paragraphs in order. So you just type all of them with, and I only pick like, I'd have, instead of Chief Justice Murphy, see, they're identifying again, I just have Murphy, right? I keep it short and sweet. Instead of Shannon Murdoch Poff, they're introducing again, still with the extra hyphen, I would just do it like Murdoch Poff or Poff, something like that. But so throughout the entire thing, you're just using that one word, right? Poff, Jones, Rossingall, right? And then at the end, when you have everything typed up, then you go up to the top and you start working your way down. And the first time you mention a person, you put in their full name and title, and then you put in the, here and after Poff, here and after Rossingall, here and after Murphy. And that way you have them identified at the very beginning. The first time they're mentioned, they're identified, and you don't have this re-identifying them throughout. Like this makes it very difficult to read. They did not at all proofread this, and they haven't proofread any of this shit. It's very frustrating. All right, so they have a summons return for Jason Jones, alleging personal service at the 7th Judicial Court. Isn't it the 7th Judicial District Court? See, like right here, they just named it. And then down here, they misname it. Instead of saying 7th JDC, oh, fucking hell. They have a period here. Like they're what the fuck are they doing? It should be like semicolon doc 2, period. Plaintiff filed a summons return for Jason Jones, blah, 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 semicolon, doc 4, period. Plaintiff filed, it's the periods, like these aren't sentences. Oh, this is very fucking irritating. Very fucking irritating. So they alleged personal service at the 7th JDC on June 9th. POF, 7th JDC. Like, why identify as 7th JDC if you're never going to use it? Oh, sorry. Yeah. All right. And then Rossingall at the 7th JDC in Estancia, New Mexico. Are there different 7th Judicial District Courts? Or is this one different? Or are all of them in Estancia, New Mexico? Or is only one of them in Estancia, New Mexico? On July 19th, plaintiff filed a certificate of service saying the order directing service, blah, blah, was served via Chief Justice Murphy's possessive proposed text email on June 21. I don't want to watch Freeman getting arrested, tased, or beaten. I don't want to watch anyone getting arrested, tased, or beaten. The fact that you get some sort of enjoyment out of seeing people arrested, tased, and beaten, show me his conviction. Otherwise, it's just the police meting out punishment without a conviction. And you should be against that. I mean, if you were smart, you would be against that. Because the only difference between you and James Freeman is the police haven't gotten around to you to arrest, beat, and tase you. Because he wasn't convicted, so they don't need a conviction to do it. So they could do it to you too. You should be against that. You're a dick. I got a boner. You're a dick. The affidavit of service by Michael Tinker stated the order directing service and setting briefing schedule was served on the court clerk at the 7 JDC in Estancia, New Mexico on June 9th. Chief Judge Murphy, Judge Murdoch-Poff, and Mr. Jones were not served the original complaint. On August 8th, plaintiff filed a notice of completion of briefing on plaintiff's motion for temporary restraining order and preliminary injunction. In support of the notice, plaintiff attaches declaration of James Springer. Why did they stop italicizing it Springer? Why isn't Springer italicized? Two of the videos, the video links referenced in the declaration are these. Are these the ones that, if I remember correctly, they mistyped these? When I went over these, they mistyped these, and so they come up with nothing, but the ones actually referenced in the complaint, you can still go to those because like one of these L's is a capital I or something like that. And I think the same thing on this. Wow, a civil code section and a vehicle code section. Yeah. So the civil code section is obviously not a misdemeanor, but we have an allegation here that a vehicle code section is going to prevent you from filming people. Let's look at the vehicle code section. Yeah, I mean, I applaud you on your extraordinary lengths to go through, but your first indicator might have been that it was in the vehicle code section. Violation of code 4008. So whoever violates these sections with the intent to capture a person for a commercial purpose. So you have to violate one of three sections. Oh, okay. So you did all the research because you're bored. I get it. Not because you're wrong. All right, perfect. So if you violate, what are those sections? Let's fucking look at those sections now. You're here because you got no fucking legs, so you can't leave. Duh. Jesus fucking Christ. You ever want a girlfriend you know can't leave you? Get a girl with no legs. That bitch is sticking around. Right where you left her. I'm going to hell. All right. So we're going down here. Rules of the road. All right. So 21701 is the first one. 21701. Additional driving rules. All right. Everybody can see 21701. So you can't interfere with the driver of a vehicle or the mechanism thereof. Trying to get a picture, so you can't violate that one where you're interfering with the driver of the vehicle to capture a visual image, sound recording, or other physical impression of another person for commercial purpose, right? That's the first one you can't do. And then there's 703. You can't follow another vehicle more closely than is reasonable and prudent in order to capture the image. Again, very, very kind of specific. And then 23103. All right, so 23103. Reckless driving. So you can't do reckless driving. All right, so you can't do any of those three things. Like, and all this because this guy wanted to prove that you can't record people in California without their consent. None of those things mention consent. First of all, wait, let's look at his fucking civil code section. Why the fuck not? Why the fuck not? Well, I'm proving you wrong. I want to prove you all the way wrong. See, what Causeless Rebel wants it to be that you can't be an auditor. That's what I'm guessing. He wants it to be. (1708.8). So this involves knowing entering into the land or trespassing. Trespassing. Like we were talking about filming people in public, and this motherfucker is. Oh, okay. Hold on a second. It's section B. My bad. So is liable for constructive invasion of privacy when a person attempts to capture in a manner that is offensive to a reasonable person any type of visual image, blah, 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 of the plaintiff engaging in a private, personal, or familial activity through the use of any device, regardless of whether it was a physical trespass, etc. So they have to be engaged in a private, personal, or familial activity. But this isn't what we're dealing with. We're talking about filming people in public. Your initial assertion was that you can't just record people in. Here we go. You said, for example, in California, you need consent from all parties to record, and none of the shit you've provided says that. So you're wrong. You should have just admitted it instead of wasting. Oh, you weren't. I wasn't showing you this. This is it right here. Instead of wasting the class's time. All right. I have no legs. I have no legs. My main X account fights auditors. I dislike them immensely. 7,700 followers are. Yeah, well, you're fucking wrong on the law, bro. Bro. All right, where were we? Before we were so rudely interrupted. On August 15th. Oop, do you see that? All right, take you down. On August 15th, 2023, filed an entry of appearance, yada, yada. On August 21st, court entered a second order amending it, permitting defendants to file a response. August 29th, counsel for defendants served plaintiff's counsel a preservation letter asking him to preserve all evidence. The day after service of the preservation letter, he stated he deleted evidence. He did. See, he thinks in his head that because it was his practice to delete the evidence, that it's all fine and dandy. However, he knew there was a lawsuit, and he knew, or should have known, that that evidence would be relevant to the lawsuit. And so he had a duty to preserve that evidence. All right. Plaintiffs filed the response. Plaintiff filed his reply. The court entered its order denying plaintiff's request and an amended order. Since entry of the administrative orders, plaintiff has continued to have access to Since entry of the administrative orders, plaintiff has continued to have access to the 7th Judicial District Courthouse and continues to video record his visits, which would continue to violate the order about filming in the courthouse, which is bad for him because he hasn't attacked the general order restricting him from filming in the courthouse. That's a problem for him. On October 1st, plaintiffs demanded law enforcement arrest court staff, and specifically Rosengal. Plaintiff also offered to reveal Miss Rossengall's home address on his YouTube live stream. That's no bueno. I keep my stocking wadded up in my pants to make it look like I have a big dick. I don't know. Are you talking about me? Am I Professor Kingsfield? So it's kind of weird that Freeman really has a problem with people getting arrested, except when he wants them to. Now he probably would say that he's doing it facetiously, but it's kind of fucked up. On November 23rd, plaintiff posted a video harassing undersigned counsel. Oh, we have that up. Hold on a second. Two hours.
Nonsense. And so we were, my close friends know, we were on our way out. And then they started coming back and refusing to do the right thing. So at this point, we've kind of decided.
Is that the one I watched? Was this the one that I was watching where he started? Huh. Well, all right. Well, let's see. Sorry, at 1 hour and 12 minutes, or 1 hour and 12 seconds. All right, you can see it. Perfect.
Look, you can't just tell outright blatant lies and not have me tell the whole world who you are. That ain't going to happen. I wonder if, and I've wondered this for a while, I think that what's actually happening here is that I think Mercedes Murphy is writing all of these motions, and then her representation is just filing it. I don't know for sure, but that's what I think is happening. I think Mercedes Murphy, because she's the I don't think that this Jade chick is this dumb. I really don't. I don't think she's this stupid, but I know Mercedes Murphy is this stupid. I mean, she'll tell a bold-faced lie. That's where what's his name? Bennett learned it from.
So he's calling all the judges liars and stuff. That's great. Then
all right. Well, this bitch be lying a lot. Her name is Jade Deflin, and she be.
So now that's the part where he's saying he called the counsel a bitch and called the underlying counsel a liar without the video. Posted undersigned counsel's contact information. The information was for undersigned counsel's prior firm, which plaintiff later corrected in his video, encouraging his viewers to harass undersigned counsel. I mean, it's not a good, it's not a good look. It's not a good look. Just like having, Turtleboy calling his people to harass. I That's another in the deleted video. James Freeman's like, I don't even know what a call flood is. God, like, dude, how stupid are you? How stupid do you think we are? Anyway, on or around November 25th, 2023, plaintiff used Chief Judge Murphy's likeness as a thumbnail for his video. Oh, on November 25th. It's like a month ago. I'm not seeing it. I don't see it. Available there. Let's try that. Oh, it's on his James Freeman channel. It's this one. So he has her with a clown nose. Nice. Nice, James. Thumbnail for his video. Judge, are you under the influence? Case dismissed. Does it actually say case dismissed? Yeah, it does. It does say case dismissed under there. Even though Chief Judge Murphy was not the judge discussed in the video, see video thumbnail, which is attached here too as Exhibit E. Legal argument. Incorporation by reference with respect to lack of service. The basis for plaintiff's amended complaint is largely the same as his original complaint. Therefore, defendants incorporate their arguments from their motion to dismiss with respect to service. In summary, defendants are entitled to dismissal of plaintiff's amended complaint because plaintiff has not effected service nor properly served the Attorney General as required under the rules of service. Chief Judge Murphy, Judge Murdoch Poff, and Mr. Jones further assert they have not been served. Defendants Mercedes Murphy, Shannon Murdoch Poff, Jason Jones, and Susan Rossigal are entitled to dismissal of all claims against them because plaintiff fails to allege how they personally participated in the actions giving rise to plaintiff's claims. I thought the chief judge is the one who issued the order. Yeah, she's the one who issued the order that he can't go into the courthouse. Oh, he told you not to call. And then he gave you the phone number. Right. Yeah. Like, you might be retarded, but judges aren't and attorneys aren't. And we understand that what he's doing is he's asking you to call. Just like all of his followers figured out that he wants them to call and harass these people. All of his followers figured it out. And his followers are probably not as smart as judges and lawyers, generally speaking. I mean, if you're a typical follower of James Freeman, you would make my case. It's axiomatic that to prevail on a damages claim, there's no damages claim against anybody but the 7th Judicial District Court. There is no damages claim except for against the 7th Judicial District Court. So why are they talking about this? And it's a Monell claim on the 7th Judicial District Court. So I don't understand this, but okay. The plaintiff must show the defendant personally participated in the alleged violation, and conclusory allegations are not sufficient to state a constitutional violation. To establish a violation of 1983, the defendants must establish a deliberate, intentional act on the part of the defendant to violate the plaintiff's legal rights. The 10th Circuit is clear that claims regarding cumulative, quote, defendants, end quote, do not establish individual capacity, personal participation. In Brown versus Montoya, the court evaluated a claim where an inmate pled guilty to false imprisonment and served time in the correctional facility. When he was released, his probation officer directed him to register as a sex offender. The plaintiff sued to be removed from the sex offender registry and the sex offender section of the probation department, and he prevailed. He then brought suit against the Secretary of Corrections and the probation officer in both their official capacities and individual capacities. Among other rulings, the district court denied the secretary's motion to dismiss. On the appeal, the 10th Circuit found that broad claims stated against groups of, quote, defendants, end quote, did not establish individual capacity claims against the secretary. In reversing the district court, the 10th Circuit relied on Iqbal for the proposition that it is particularly important that the complaint make clear exactly who is alleged to have done what to whom, and provide each individual with fair notice as to the basis of the claims against him or her, as distinguished from collective allegations against the state. A review of the complaint illustrates a lack of allegations regarding the type of participation required to establish individual capacity liability. The complaint makes general, conclusory assertions for relief against Chief Judge Murphy, Judge Murdoch Puff, Mr. Jones, and Ms. Rosengal, but does not assert any factual claims of liability. Plaintiff does not identify specific actions beyond conclusory allegations without supporting factual averments taken by particular defendants that could form the basis of a constitutional violation. It is difficult to understand against whom plaintiff alleges his claims or what factual allegations support those claims. In count 1, plaintiff alleges a claim under 42 U.S.C. 1983 predicated on violations of the First Amendment rights to freedom of the press and speech. Plaintiff alleges that Chief Judge Murphy and Judge Murdoch Puff Murphy, there is now a Judge Murdoch Puff Murphy. There, apparently, Judge Murphy and Judge Murdoch Puff got together, did a little bit of scissoring action, and created a baby, Judge Murdoch Puff Murphy. How can a certain act be against the law in district court but not in superior court? That's a malformed question. Certain acts can be punished or prohibited in certain courts depending on the jurisdiction of that court. An act is against the law if it's against the law. If there's a statutory or a common law prohibition against it with something to follow up with, some sort of a mechanic to enforce it. So your question is malformed. I don't believe that a certain act can be against the law in one court but not in another court. One court will have jurisdiction over it, the other court won't, is I think what you're going after. So this new judge, Judge Murdoch Puff Murphy, colluded with Chief Judge Murphy to engage in viewpoint discrimination by banning and excluding plaintiff from a public places, plural, and hearings, plural, prohibiting him attending and reporting on public matters. However, the remaining defendants are not named in the count 1 heading, and plaintiff did not plead any facts to support any claims against them. Nor are there any factual allegations pled in the complaint concerning any First Amendment violations committed, only conclusory statements. Plaintiffs also allege retaliatory actions, but similarly fails to plead any factual allegations concerning retaliatory actions. It is unclear what actions Judge Murphy and Judge Murdoch Puff Murphy, again, It's Murdoch Poff Murphy. It's still Murdoch Poff Murphy. We're on page 14 out of 27. It is unclear what actions the judges took that could be characterized as viewpoint discrimination, or what conduct were retaliatory actions, much less how plaintiff was allegedly injured. The First Amendment is violated when a government actor precludes constitutionally protected speech because of the viewpoint expressed. Plaintiff has not pled facts that demonstrate how how defendants have precluded plaintiff's speech, nor what viewpoint he is not allowed to express. How? Accordingly, plaintiff's claim fails and should be dismissed. Despite the harassment defendants have experienced from plaintiff, none of the defendants, nor anyone on their behalf, has taken reported plaintiff's YouTube videos. Has taken reported plaintiff's YouTube videos. Despite the harassment defendants have experienced from plaintiff, none of the defendants, nor anyone on their behalf, has reported plaintiff's YouTube videos. I don't fucking know. Oh, that's another thing. So Freeman, in the video he took down, was talking about how the only way you can get a video taken down for scams is by having multiple people report it. And his team, his back end team, helped him get that undone right away. And again, he doesn't understand it, but this undermines his argument. If the state is actually exerting influence on YouTube to essentially force YouTube to do the state's work to violate your First Amendment, i.e., the state is using YouTube as a tool. It's the state doing it. YouTube's just the mechanism that the state is using to deprive you of your First Amendment rights. That means that the state has to have some sort of a influence or control over YouTube. They have to say, like, if you don't do this, we're going to do something to you, or otherwise exert some sort of an influence on it. It's not brigading. I mean, anyone can get together a group of people to try to false flag a video to get it pulled down, to mass report. That's not what you have to allege. So Freeman has now alleged two different things, and what he says can be used against him. So it's really stupid. It's really stupid that he made that video. He made so many faux pas in that video. He would be a fool to put that back up. I can only assume that his attorney had the good sense to tell him to take that fucking video down. In count 2, plaintiff alleges a claim under 42 U.S.C. 1983 predicated on substantive due process violations. The heading in count 2 does not specify which defendants I believe this is a female attorney. How dare you assume her gender? How dare I assume her gender? The heading in count 2 does not specify which defendants count 2 is asserted against, but alleges that, quote, defendants' actions constitute deprivations of those rights contrary to substantive due process. What the fuck does that even mean? I don't know. While plaintiff claims he was afforded no due process, he omits that there was a hearing scheduled on June 16, 2023, to address his misconduct at the 7th Judicial District Courthouse. Similar to count 1, there are no factual allegations pled in the complaint concerning any substantive due right or substantive due violation, any substantive due violations. Similar to count 1, there are no factual allegations pled in the complaint concerning any substantive due process rights violations committed, only conclusory statements, and it is unclear what actions any defendant took that could be characterized as such. Because plaintiff has failed to state a claim, count 2 should be dismissed. In count 3, plaintiff alleges claim under 42 U.S.C. 1983 predicated on procedural due process violations. Again, the heading in count 3 does not specify which defendants count 3 is asserted against, but Murphy, Poff, Jones, and Rossingall are the only defendants named in count 3. Plaintiff states that administrative, quote, orders issued by defendants Murphy, Murdoch, Poff, Jones, and Rossingall deprive plaintiff his fundamental liberty interests in speech, press, and petitioning without due process of law, based solely upon discretion of the defendants. End quote. Well, Jones and Rossingall can't issue administrative orders, so I don't see how they would be at all at fault in that, but whatever. Similar to counts 1 and 2, there are no factual allegations pled in the complaint concerning any procedural due process rights violations committed, only conclusory statements, and it is unclear what actions any defendant took that could be characterized as such. Accordingly, plaintiff's claim fails and count 3 should be dismissed. The complaint, I'm assuming we're talking about the amended complaint in all this. I'm assuming. The complaint, as in Brown, quote, fails to isolate the allegedly unconstitutional acts of, end quote, these named defendants. Accordingly, for the reasons expressed in Brown, plaintiff's complaint fails to state a plausible cause or a plausible claim against the individual capacity defendants because it lacks any substantive allegations that the individual capacity defendants took any individual act which deprived plaintiff of a constitutional right. Further, the complaint contains no allegation which meets the 10th Circuit's test for personal participation, including knowledge, policymaking, deliberate indifference, and personal conduct. Because the amended complaint contains broad, conclusory allegations, the claim fails to state an individual capacity claim, and the claims against Mercedes Murphy, Murdoch Poff, Jones, and Rossingall should be dismissed. Plaintiff's federal claims are barred by qualified immunity. Given plaintiff's failures to state any valid claim for relief, plaintiff's request for damages necessarily fails as well. Am I taking crazy pills? Am I taking crazy pills? So count 1, he's seeking declaratory relief and injunctive relief. That's count 1. Count 2, declaratory and injunctive relief. Count 3, declaratory and injunctive relief. Count 4 is not an 18 U.S.C. 1983. This is solely against the 7th Judicial District Court. Actual damages. He's seeking actual damages. That's monetary. So he's only seeking monetary relief against the 7th Judicial District Court. He's not seeking it against any of the individuals. Oh, bitch, we knew you were crazy. God damn, you'd be wild in bed, wouldn't you? Oh, dangerous. Dangerous, but wild. It looks like all of these are just violations of the New Mexico Constitution, except the only one it specifically alleges is New Mexico Article 2, Section 17. Fuck, it's like two of the world's worst attorneys fucking flailing away at each other in a dark closet. And you don't know which one's gonna walk out. So this entire section is stupid. They're talking about qualified immunity. There's no damages. There's no fucking damages alleged. There's no damages alleged. There's no damages alleged. There's no damages alleged. There's no damages alleged. So count 4 alleges an article or a violation of Article 2, Section 17, 18, and 23 of the New Mexico State Constitution against the 7th Judicial District Court only. This is a good point. This is a fucking good point. So it appears, I don't see anywhere in here that there's Monell liability. There's no Monell claim in here, right? So there's no Monell claim. So the only cause of action against the 7th Judicial District Court is violations of New Mexico law. Only violation of New Mexico law. So they have a defendant in here where the only cause of action is a state claim. There would have to be diversity of jurisdiction, which they're not alleging. They can't allege. So there is no the argument should be pretty clear that the federal court doesn't have jurisdiction over the claims against the 7th Judicial District Court. And like chili and blue bacon. I don't know, man. Like, yeah, it kind of is. Like, this is hard. This is hard for me because, like, it's so bad. And these are like when it's Chille being a dipshit, it's kind of fine because like I don't expect him to have any level of professionalism. I expect him to vomit up verbal diarrhea. I expect it. I always expect attorneys to have a level of professionalism, like the modicum, like the bare minimum of spell check and grammar check and proofreading. Like not making an argument about damages when it's like very clear that damages aren't alleged. And Freeman's attorney is no better. I mean, these are both terrible, terrible fucking attorneys. All right. Plaintiff state's defendant violated his constitutional right of freedom of speech, press, freedom of assembly, and due process. So let's see. So this is only He's not arguing any which constitutional rights? See, I think he's talking about these constitutional rights because that's what's in the header. Speech is New Mexico Constitution, yada yada. Boy, this is just so poorly. It's just so poorly done. Merry Christmas to you too, Papa Sanser. Well, no. So James likes this attorney. He really does. His plaintiff's attorney, James likes him. The guy has a lot of James-like ideas, and I hear you, buddy. They have a lot of similar ideas, which is why this particular attorney, the plaintiff's attorney, what's his name? Blair Dunn. That's why this motherfucker sued the New Mexico Supreme Court and lost and got sanctioned, because he's a fucking dumbass and he takes shit too far, much like Springer does. And Springer misinterprets that as being a good attorney. So Springer actually likes this guy. He likes Blair Dunn. He thinks Blair Dunn is top notch because he sued the New Mexico Supreme Court, lost, and got sanctioned for it. Unfucking believable. But that's the metric Springer wants to use, and so there you go. All right. So why the fuck are they against 7th Judicial District Court only? That's no other causes of actions or against the 7th Judicial District Court. He states that the defendant, 7th Judicial District Court, violated his constitutional rights for the New Mexico Constitution. So he failed to state a viable claim, not because he didn't allege anything, but because what he fucking alleges. Oh, they're wrapping up. They're wrapping up. Because plaintiff failed to state a viable federal claim in counts 1, 2, and 3, those claims should be dismissed. Claims for counts 1, 2, and 3 should also be dismissed because the individual capacity offense are entitled to qualified immunity. They're not. This leaves plaintiff's state law claim in count 4. But you're missing the fact that it is the only cause of action against the 7th Judicial District Court. So as to that defendant, the only claims are state law claims. So as to that defendant, the federal court has no jurisdiction. Oh, I'll take that in heart. Dude, Kevin, have you seen Shiz without her filter on? Do a Google search for Shiz without her filter. It's fucking disgusting, bro. She's lying to you with that filter. It's a very good filter. It takes her from a 2 to a 10, but you won't have that filter IRL, bro. You won't have that filter IRL. Oh, you know, Alerica, this is a filter too. That's a filter too. She's a much girthier lady than that, but that's fine because I almost guarantee you she has big old titties. But Shiz does not have big old titties, and she's like a fucking sack of used diapers, and she's ugly. But my God, that filter is good. Isn't that filter good? The complaint should be dismissed because the court does not have jurisdiction over this matter. Interesting. The Worker-Feldman Doctrine provides the United States District Courts do not have jurisdiction over challenges to state court decisions, in particular cases arising out of judicial proceedings, even if those challenges allege that the state court's actions were unconstitutional. Okay. Under the Rooker-Feldman doctrine, lower courts are precluded from exercising appellate jurisdiction over final state court judgments. I don't even think that in this particular case there is a final state court judgment because there was a hearing set. If what the defendant's counsel is alleging is true, there is a hearing set on the OSC, order to show cause. Now, there apparently was a criminal contempt action that was filed, but the prosecutor declined to prosecute it, which is different than an OSC, which is quasi-criminal. It's still in the civil court, but it's where the civil court basically can give you fines and or jail time, but it's not a criminal proceeding. You wouldn't get it wouldn't show up on your criminal record. It's quasi-criminal. Yeah. Crazy's great in bed, but then as soon as you get him out of bed and you have to actually fucking talk to him, then it's all bad. Been there, done that. Got the fuck out. If the state court decision was wrong, that did not make the judgment void, but merely left it open to reversal or modification in an appropriate and timely appellate proceeding. Yeah, but again, it's not even there. There is no final judgment. This is essentially like a habeas attempt at habeas when there is no final judgment. There's only the beginning stages of it. Federal district courts lack the requisite appellate authority for their jurisdiction was strictly original. I haven't had the gnaw off a limb yet, but I've definitely had decisions made at night that I've regretted in the morning. This doctrine applies to federal cases brought by state court losers complaining of injuries by state court judgments rendered before the district court proceedings commenced, and inviting district court review and rejection of those judgments. So that's why I'm still wondering what precluded Freeman from appealing any of this. Merry Christmas to you too. And if your dog actually passed away, then I'm sorry to hear that. Whoever you are. So all dogs are good dogs. Here, plaintiff is disputing a state court decision, specifically the administrative orders limiting his access to the 7th Judicial District Courthouse. His claim, therefore, depends on this court finding the state court or the state courts erred in entering the orders. Rooker-Feldman prohibits such review. I believe that is probably the case. Oh, man, dude, I'm sorry to hear that. I am sorry to hear that. Well, my best recommendation to you is to get a new puppy for Christmas because nothing mends a broken heart like a new love. I think Shannon only looks like Kevin. I don't know that Shannon is Kevin. The yada, yada, yada procedural, the order should be reviewed by the New Mexico Court of Appeals. I'm assuming it's Court of Appeals, not New Mexico Court Appeals, and the New Mexico Supreme Court. In the absence of an express statute or rule, no appeal will lie from anything other than a formal written order or judgment signed by the judge and filed in the case or entered upon the records of the court and signed by the judge thereof. Instead, plaintiff is attempting to appeal what is fundamentally a state claim to this court. Rooker-Feldman prohibits such review, and plaintiff's complaint should be dismissed for lack of subject matter jurisdiction. I agree. I don't understand why he didn't appeal. And I don't think you could just rest on your laurels. I don't think you could just fail to appeal, wait for the time to run out, and then not appeal. Complaint should be dismissed as a sanction for intentional spoliation of evidence. I don't know if they'll get this. I don't know if they'll get this. It is well established that they might get some kind of sanction, like the the court might say that that the jury can draw adverse inferences from the deletion of the evidence, etc. But I don't know if the complaint will be dismissed as a sanction. Oh man. Oh dude. Oh, I feel bad for you now, brother. I'm surprised you came back on and put me on anyway. So let's lighten the mood here. Woo! Spoliation sanctions are proper when one. Oh, I'm sorry. It is well established that litigants are under an obligation to preserve evidence when the party has noticed that the evidence is relevant to litigation, or when a party should have known that the evidence may be relevant to future litigation. That's the part that that Chille, or not Chille, Springer seems to forget. Springer and his attorney seem to forget. They fixate on when Springer received the notice. That doesn't really play out though, because when Springer was contemplating future litigation, at that point he had a duty to preserve the evidence. Spoliation sanctions are proper when one, a party has a duty to preserve evidence because it knew or should have known that litigation was imminent. Merry Christmas to you too, Fish. And two, the adverse party was prejudiced by the destruction of the evidence. Oh, are you going to be able to show that you were prejudiced? Well, I don't know if you can. I don't know if you can. To date, the defendants haven't identified anything prejudicial about him deleting the evidence that he deleted. So they're actually going to have to make some showing that they're prejudiced by it. Furthermore, the court has discretion to fashion an appropriate remedy depending on the culpability of the responsible party and whether the evidence was relevant to proof of an issue at trial. See, they need to show that what he deleted was relevant to proof of an issue at trial. We'll see if they actually get to that proof. Stop it, you guys. Happy thoughts. No dogs die on or around Christmas. That's a new rule. It's a new rule. The federal court has the inherent power to sanction a party who has abused the judicial process. The spoliation of evidence is one such abuse. Spoliation is the destruction or material alteration of evidence or failure to preserve property for another's use as evidence in pending or reasonably foreseeable litigation. So he has a duty to preserve evidence. Yeah, we know about that. His deletion demonstrates culpability and intent. Well, let's see what they have to say here. Culpability refers to the degree of fault to be assigned to the offending party. Courts have not been uniform in defining the level of culpability, be it negligence, gross negligence, willfulness, or bad faith, that is required before sanctions are appropriate for evidence destruction. So they're saying that his destruction of evidence demonstrates culpability and intent, but then they go on to say courts have not been uniform in defining the level of culpability that is required before sanctions are appropriate for evidence destruction. Culpability can range along a continuum from destruction intended to make evidence unavailable in litigation to inadvertent loss of information for reasons unrelated to litigation. That's where James's statement that he, as a habit, as a rule, deletes all of the emails and stuff after he's read them. So that is going to minimize his culpability. The 10th Circuit requires bad faith for spoliation of evidence. The general rule is that bad faith destruction of a document relevant to proof of an issue at trial gives rise to an inference that production of the document would have been unfavorable to the party responsible for its destruction. That I can see happening if they could prove that the document would have been useful at trial. Mere negligence in losing or destroying records is not enough because it does not support inference of consciousness of a weak case. Conversely, willfulness is equivalent to intentional, purposeful, or deliberate conduct. While bad faith requires instructions for the purpose of depriving the adversary of the evidence for willfulness, it is sufficient that the actor intended to destroy the evidence. Interesting. So just because you've destroyed the evidence, that means it's bad faith, according to Buckley versus Mukasey. Here, plaintiff, not plural or possessive. Here, plaintiff publicly declared he deleted evidence just after receiving a spoliation letter. I thought he said that he deleted the evidence, all evidence, like he deleted emails as after he read them. I don't know that he declared that he deleted evidence just after receiving a spoliation letter. The near immediate timing of plaintiff's spoliation conduct demonstrates it was intentionally. I don't recall him doing that. Plaintiff's spoliation of evidence prejudices defendants. Prove it. The moving party carries the burden to establish a reasonable possibility based on concrete evidence rather than a fertile imagination that access to the lost material would have produced evidence favorable to his cause. At the same time, courts must be careful that application of this burden is not too onerous. Otherwise, a spoliating party might be allowed to profit from its own misconduct. Plaintiff's blatant destruction of evidence immediately after the preserved plaintiff's blatant destruction of evidence immediately after the preserved has prejudiced defendants. That sentence makes no sense. I think what it means is plaintiff's blatant destruction of evidence immediately after receiving the preservation letter has prejudiced defendants. Given plaintiff's documented misconduct in the 7th Judicial District, it is reasonable to infer that plaintiff took down videos and deleted evidence which demonstrate additional acts of misconduct. See, now we're inferring. It just said that based on concrete evidence rather than a fertile imagination. And then they go right to a fertile imagination. What shit tier argument. Plaintiff's complaint should be dismissed as sanction for harassing defendants and defense counsel. Oh my God. She already has a fat head, dude. She has a fat everything. Merry Christmas to you too. So this, I don't know why the fuck they think that this is a thing. I guess we'll find out, right? The analysis for dismissal utilizes a 5-factor test from the dismissal as a sanction framework for discovery violations. Well, this isn't a discovery violation. This non-exhaustive list of factors help guide the determination of whether dismissal is an appropriate sanction. The factors are: 1, degree of actual prejudice to the defendant caused by the misconduct. Why are we talking about discovery violations? I don't find anything interesting what's going on in Chille right now. So I looked at it and I said that Chille's not going to win his motion for reconsideration. And I explained why. So that was it. That was all I went over on it. Because I'm not going to read a long opposition for something that's blatant and in your face. And whether or not the opposition is good, the court's going to deny it because Chille has no idea what the actual basis for a motion for reconsideration is. So that was it. I'm not going to spend 20 years on it. The non-exhaustive factors consider the damage done, culpability, blah blah blah. These factors, degree of what? So right now they're analyzing dismissal as a sanction for harassing defendants and defense counsel under a rubric for discovery violations, but this isn't a discovery violation. So all of this is just wasted paper. Wasted paper. Jay Delphin, you suck as an attorney. Or at least everything you've put out to date sucks. Like, I don't know why Brian Garcia and Rodney Gabaldon are allowing you to write these and not reviewing them, because these are just pure shit. Anyway, so the good arguments were the failure to serve, if true. Good argument, failure to Twickball, failure to adequately plead facts to put them on notice. Those are good. The dismissal of it was a bad argument, but a high chance of success because of the actuality for dismissing against the 7th Judicial District Court. That has a high probability of success. Low probability of success on the 12B6 for the qualified immunity. A low probability of success for dismissal based on spoliation or other harassing defendants and defendants counsel. So that's kind of where I'm at. I think it will be dismissed with leave to amend to afford Blair Dunn an opportunity to accurately and adequately plead his causes of action instead of making legal conclusions. He should actually plead facts. And that's where we're at. So that's all I got for today. People are still talking about dogs getting sick and dying, which is terrible. I'm not going to put those up. Dogs are awesome. And my dogs are all going to live forever. Thanks for watching and have a great day and Merry Christmas.